Yes. Item 4, my lord. This, my lord, there is some mistake, my lord. Suppose it should be 7, but it is between 9 or 9 to 8. Only a respondent number. My lord. May I allow to correct my hand? Item number 4. 4, my lord. Okay. Well.
I need to mention why that may come up for admission next week, my lord.
Why?
Matter is urgent matter.
Urgent, every matter is urgent.
Relating to my pension matter. She is out of nothing, getting nothing, either salary, not my lord pension.
Why will you
Every
get a
yesterday my
salary
item was listed by order my lord.
Understood,
Again,
but matter has to be urgent means what is the urgency?
Because 2018 matter my lord.
Okay. We'll have it on 19th May.
My
I'd like to mention for item number 19, Lordship. Maybe possible for
Your name?
I'm appearing on behalf of Keller Mutundar.
At the request of the Learned Council for the petition,
Okay,
matter stands adjourned for 4 weeks.
Next week, the date may be
Lordship, I beg to mention for listing WC 26/2022. Lordship, matter may be listed after 1 week.
Why?
Urgency, my lord.
What is the urgency?
Because this matter 22 matter.
Why? What is the urgency, Mr. Council?
This is the pension matter, my lord.
Pension, all the matters out here before this court are all pension matters. Then what is the urgency to give you out of turn?
This matter also 2022, my lord.
That is why it is not more urgent. Why? What is the urgency? Think about it. Mention it again on Monday. Yes. Next.
Monday, my lord.
Monday you mention the matter. Think about it. What is the urgency? I don't allow urgent matters. Again, mention the matter. Think about it. Or go to the registry. Talk about it. Yes.
Item number 23.
Yes.
Can we take up it at 2 years?
Why?
The matter is related to inspector teacher and it is covered by your lordship judgment. Last location your
Secondary.
Lord.
We'll take it.
At 2 years. Okay.
Number 1 for withdrawal.
petitioner want to withdraw with liberty, my lord.
Why liberty?
My lord, petitioner got other benefits, my lord, except the monthly pension, my lord. Treasury officer asked the petitioner to submit a withdrawal order, my lord. Therefore, he wants.
So then why liberty?
They will release the monthly pension after issuing of the withdrawal order.
Is it so?
Yes.
Treasury officer said so.
Yes.
We'll talk it out with the treasury officer. Where is the government? The
As per
treasury
my-
officer. Which treasury? That they want the withdrawal of the writ petition for the purpose of.
Naharpati Authority.
Okay. Yes, Mr. Solia. This item number 1. He has been asked to withdraw the petition in order to get his pension.
And monthly
Pension.
Yes.
Otherwise, the treasury officer says that he would not be releasing the pension. How is it?
Lordship,
Doesn't it amount to interference with the course of justice?
Lordship, here last what I remembered, Lordship, there was some problem from the end of the.
that was cleared, my lord. Other benefits.
This court would like to take note that in the earlier order dated demand, this court specifically directed to appear before the treasury officer Nahal Katia for verification of the specimen signature and identification as sought for. Yes,
That was
I
done.
remember.
That was done.
Then
Before the treasury.
why are you saying you put it on affidavit?
If you want liberty, it's a different thing. You want a withdrawal, it's okay. But once you ask for liberty, you have to give me a good reason for that. And if you say that it is because of the treasury officer insisting that you withdraw the petition, then it will be. I think you better put it by way of an affidavit. Otherwise, I'm not going to give the liberty. What do you want to do?
I have to ask the client, my lord, and then Tuesday, my lord, maybe that
Not Tuesday.
yeah.
Matter will come up. Your name?
K. Kolita.
Or Mr. K. Kolita, the learned counsel for the petitioner, and Mr. A. Solia, the learned counsel appearing on behalf of the Treasury Officer Nahar Katia, and Mr. P. Hazarika appears for the respondent number 4. Today, the matter has been listed for withdrawal of the instant writ petition. However, the petitioner seeks a liberty to file afresh. This court made a pointed query upon the learned counsel for the petition as to why he seeks the liberty to file afresh. During the course of the hearing, the learned counsel for the petitioner submitted that the Treasury Officer Nahar Katia had made it a condition precedent for releasing the pension to the petitioner for withdrawing of the instant petition. This court is of the opinion that such statements, if so made, is required to be placed by way of an affidavit, as it is a very serious allegation being made against the Treasury officer. The learned counsel for the petitioner seeks an accommodation. Let the matter again be listed on 15th of May.
At number 2 from Boston.
Matthew.
Yes.
Well, the petitioner is the first wife of the deceased husband, my lord, and her name was not incorporated in the service book, and the office.
You should directly release the area as well as the current service as well as pensionary benefits, so and so, as well as the so and so. Yes, what do you want?
And the monthly family pension or compassionate family pension.
When did the petitioner die?
Petitioner died,
The
my lord.
petitioners who died?
Petitioner
Husband.
husband, my lord.
When?
Died on my lord 5/4/2023.
5/4?
2023.
22 or 23?
23.
20? Withdraw, file a fresh after some time. What is this? 5/4/2023, somebody dies and now you are asking in the month of May?
No, my lord. What happened there? She has submitted the representation. My lord.
Understood. Representation, do you mean that they will work as a superhuman body out there? They will do so. It will take some time. Wait for at least 3 months for that. You can't ask this court immediately, a person retires and tomorrow you come before this court. This court is not going to do all this.
My lord, the petitioner is before this court for a different reason.
Oh.
Second wife is claiming, my lord.
Two wives.
Two wives.
Two wives. She is the
First wife.
if I go by this petition, my lord, the petitioner claims that there is another wife, and she has also approached the authority. So that is a dispute. That is why.
No, but whatever may be the dispute, the person died only on 5/4/2023.
Yeah.
Let the authorities decide. The authority have the law out there and then they should be knowing it. Why should this court keep on saying everything that you do this? This is not a routine matter for that.
That is why, my lord, they have
Wait for some time.
petitioner.
Let them come up with something. This court is not.
It is too early, my lord.
Too early. I'm not going to interfere.
5/4/23.
That day also one matter came up as regards recovery. There is no order for recovery. He has retired. He, without submitting a representation, he has come. This court will presume that the authorities know the law.
This
So
is
they will take a due course. If you are the first wife, you will get it. It is the second wife should come in. No, nothing doing.
So, my lord, my humble prayer as on today, my lord, he has submitted a representation, my lord. Let the authority take a note of this matter.
Why should I say about anything about representation?
He
You
will,
withdraw, then I may give an observation, slight observation, nothing more than that.
as your lordship,
Heard Mr. B. Pukasko, the learned counsel for the petitioner. Mr. Ardhor appears on behalf of the
1 to 6, my lord.
respond number
1 to 6.
1 to 6.
I am for
Mr.
8.
So and so, R. Ahmed appears on behalf of the respondent number 8. Taking into account that the husband of the petitioner expired only on 5/4/2023, and the representation was submitted on
18/4/2023.
18/4/2023. The learned counsel for the petitioner submits that instead of pursuing the petition, he may be permitted to go ahead with the petitioner would take steps before the authority concerned for consideration of the representation. And as such submits that he may be permitted to withdraw, but with the liberty that if at a later stage it is the authority concerned does not consider the representation, then the petitioner may be given the liberty to approach this court again. Taking into account the said submission, the matter stands dismissed on withdrawal. However, the petitioner is at liberty to take steps before the authority concerned, in respect to the representation submitted on 18/4/2023. So it is further observed that if the petitioner is aggrieved after a reasonable period, it is aggrieved by the representation being disposed against the petitioner, or no action being taken in respect to the representation after a reasonable period, would be at liberty to approach this court.
Right.
At number 3,
Petitioner is
Yes, Mr. Bhardwaj.
petitioner is before your lordship for the inaction on the part of the director to release the ADR increments benefits. My lord, it's at page 31. The proposal has already been sent by the DO to the director.
Amounting to remand for the period from remand to remand by bringing the entire exercise to a logical conclusion with the order dated so and so. Yes, where?
My lord, page 31.
The requirement of fund of release of area salary.
My lord,
What is your name?
my lord, Anwar Hussain
Anwar
Faruqi.
Hussain.
Check number
This is amount 11,91,000. 11,91,000.
785.
Why for the same period two amounts?
My lord, this has rolled down from that OPP matter, my lord, from that 4040 OPP matter.
Okay.
After the disposal of by this honorable court, the director of elementary education has passed an order in the year 2019 saying that all of these assistant teachers working in different schools are entitled to all these benefits. All these assistant teachers working in different schools are entitled to such benefits. That order I have also annexed.
Okay, very well. Now then,
Today, my lord,
no, but one is Rampur, same person. Oh no, you are. It's a different person. Anyways, your amount is 11,91,785. So you are entitled to that amount.
yes, my lord, but the director will verify.
This has been written by the district elementary officer to the director.
Yes.
But the director is not doing anything for the last 3 years.
My lord,
2 years.
on the very next page, my lord, the director has asked the TEO for the relevant documents. And that has
Understood, but that is in 2021.
already-
You are aggrieved by non-action, inaction on the part of them for releasing this amount.
let them verify and pay. That is what.
Verify and pay.
Verify, and if I'm entitled, the director will pay. Pass an order. That is all. Limited.
So, what to do?
Bilateral issue notice, short notice.
In fact, item number 22 and 45 before your lordship, notice was issued, no reply has come. That is a old matter. Exactly similar. 22 and 45 before your lordship.
22 and 45. Okay, we take it up. You are the person. You are the other side. We dispose it of to verify and pay.
Keep entitled.
Yes, yes.
Obvious. Then why I am asking for verification? I am not directing you to pay. 22 and 45. Get it?
In 45, the only difference is his.
Now you come up with a
his school was amalgamated along with a high school. That's why there the director of secondary education comes to play.
there also he only appears. But the issue remains the same. Okay, tell me what is the issue before they get the file? Where is the order
My lord, the order of the director
of this court?
of this court is at page 23. It starts, my lord. Page 26.
Page?
Page 26.
Yes. What does it say? In view of the matter disposed of with a direction to the respondents to finalize the regularization of the petitioners. Service from so and so, payment of regular salary as per the pay scale prior to Iman, and examine and decide the question of payment of pension to the petitioner as indicated above within a period of 3 months from so and so.
Thereafter, the commissioner.
First and foremost, Mr. Counsel, couldn't you get a copy of a certified copy of this order? Or is it not available? Half of it can be read. By way of this petition has prayed for giving effect to the regularization of the services from so and so, and for making regular payment of salary as per the pay scale prior to Iman, with pay protection and regular increment. Proceeding, this court had passed order on so and so and so and so, and pursuant to the commissioner and secretary issued an order dated so and so to the effect that the OBB so and so for getting their due salary with incremental benefit and continuation service is allowed, and the government instructions issued earlier in this regard may be modified. The Commissioner and Secretary to the Government of Elementary has also issued a letter to the Additional Advocate General and the Senior Standing Counsel area in respect to the present stage, which is reproduced. With reference, I am likely to say that the government in the education so and so had examined the Honorable High Court's order dated with a view to comply with the Honorable High Court dated demand to allow the petitioner regularization benefit with effect from 24/4/1998 towards payment of the regular service. However, as the view and approval of the Finance Department is where the matter was referred to the Finance. Since the matter is still the Finance is advised the Department to obtain views of the Judicial Department on the matter. Accordingly, the state file has already been endorsed to the judicial requested. Appearing on the submits that the petitioner to regulation with regular has been adopted or dated issued by the Commissioner and Secretary to the Assam and the views of the petition to finalize the question of regulation before it whether the petitioner will be covered by the Assam review. In that view, without the direction regulation service from payment Now tell me what is your case?
But after that High Court's order, my lord, the Commissioner of Elementary Education has passed an order on 29th of June 2019 at page 27.
It appears from the records and reports that the petitioners were appointed during 1998 onwards and were receiving salary in regular schedule with regular incremental since the date of joining, that is till a month. Subsequently, in compliance with the High Court's order, the government has to regularize the services becomes permanent demand. Services of teachers were regularly adjusted by So this is what the order is of the Director of Elementary Education.
But this is the Commissioner.
Okay, in view of the findings of the prayer of the Imam, it's hereby directed regularization of service of Imam. And also, what is this order? That order is the order passed by Justice H.N. Sharma. 4040.
This is by Honorable Justice Michael Johan.
No, this order at the decision in view of the above findings. Above findings is in respect of. Okay.
My lord, that the paragraph above that one, my lord.
As per the recommendation, even the finance so and so has vetted the draft speaking order and conveyed no objection for awarding the past service to the 2044 numbers of among the group of so and so across the state in compliance with the orders dated so and so and so and so. And for counting up the past service of OVB teachers under rules so and so, the invoking of the school rule does not appear necessary in the instant proposal for the time being. So this is the order.
Yes.
So thereby giving benefit to that 24040. Now you are within the 4040 batch.
That's why the proposal.
In pursuance to the order dated so and so, the following are allowed to draw regular salary with incremental benefits since the date of their joining. Now this is you are
I'm number 2,
Anwar Hussain, and the other is
others, my lord.
Anwar Sadat.
My lord, different orders are annexed.
So they have the same thing.
My lord.
Afia Khatun.
Only in Afia Khatun, my lord, I have said that it's a secondary education, and also there is no proposal. So
then
the entire play ends at the commissioner's order. In Afia Khatun, my lord, the commissioner's order, after that, no development has taken. I have simply filed a writ claiming the area increment from my date of regulation.
So that Afia Khatun is a different matter.
There is no proposal.
So there is no proposal. So then we have to see what is the stand in the affidavit what they do. So these two matters, no?
Yes. Anwar Sadat, I have annexed the proposal.
Into the WPC number 3811/2021 and 2519/2023. Heard Mr. P. Bhardwaj, the learned counsel, appearing on behalf of the petitioner in both the petitions, and Mr. N.J. Khatonia appears on behalf of the Elementary Education Department. From a perusal of the petition, as both the petitions involve similar facts and common questions of law, both the petitions are taken up for disposal together. The issue involved herein is limited to the entitlement of the petitioners in both the writ petitions to the increment, area increment for the period from 1/4/1999 to 28/2/2019. Both the same. Huh? In both matters, same.
My lord, in Anwar Sadat, it is with effect from 24/4/1998.
Amount in both the is relates to payment of the claim of the area incremental benefits to the petitioners from the date of their joining, initial joining. Regular. From the date of their initial joining.
Joining will create a problem, my lord. It is regulated because the orders also say regulated.
From the date of their regularization. In WPC number 3811/2021, the petitioner herein was regularized on 24/4/1998, whereas in WPC number 2519/2023, the petitioner was regularized on
1/4/1999.
1/4/1999. In WPC number 3811/2021, the petitioner is claiming the area the incremental benefit to the tune of rupees 11,97,740 for the period from
24/4/1998
till
till 28/2/2019.
Where?
My lord, page 31, my lord, of
31.
of Anwar Sadat. Yes,
What does it say?
my lord, for an third line, my lord, for an amount.
Incremental benefit from 1/7/2011 to 36/2014.
No, my lord, page 31 of Anwar Sadat.
Not Anwar Khatan, this one. Anwar Sadat. Page 31 says what? Is annexure 9.
Just 24/4/1998.
Then till when?
My lord, come to that annexure 10, my lord.
Annexure 10.
10. Yes.
Oh, that's page 32.
Yes, so there the third line, my lord, 11,97,740.
11,97,740 with effect from 24/4/1998 to 28/2/2019.
Yes.
And in WBC number, the petitioner is claiming the area incremental benefit of an amount of rupees 11,91,785 for the period from 1/4/1999 to 28/2/2019. It appears on record that in both the petitions, the district elementary education departments officer, district elementary education officer, had issued communication to the director of elementary education for payment of the area incremental benefit to the tune of rupees 11,97,740 by communication dated 21/1/2021 in WPC number 3811/2021, and the amount of rupees 11,91,785 by the communication dated 4/1/2021 in WPC number 2519/2023. It is the grievance of the petitioners in both the writ petitions that in spite of such letters being issued by the district elementary education officer, the Director of Elementary Education have not taken any steps in that regard for the last 2 years, and consequently, the petitioner has been deprived of his arrear incremental benefits. Mr. N.J. Katunia, the learned counsel appearing on behalf of the Elementary Education Department, submits that the instant writ petition can be disposed of with a direction to the Director of Elementary Education Department to make necessary verifications and then to release the payment if it is found that the petitioners are entitled to. Taking into account the facts involved as well as the submission of Mr. N.J. Katunia, this court, in the interest of justice, disposes of both the writ petitions with a direction to the Director of Elementary Education Department to make necessary verification as deemed fit in respect to the communications forwarded by the District Elementary Education Officer dated 21/1/2021 in the case of the writ petitioner in WPC number 3811/2021 and communication dated 4/1/2021 as regards the writ petitioner in WPC number 2519/2023. And thereupon, if it is found that the petitioners are entitled to the said amount be released to the petitioner, the said exercise be completed within a period of
3 months.
3 months from the date a certified copy of the instant order is served by the respective petitioners to the Director of Elementary Education. This one, we will say, other one, is Khatun, Afia Khatun. Heard Mr. P. Bhardwaj, the learned counsel for the petitioner. Mr. N.J. Khatuni, the learned counsel appearing on behalf of the Secondary Education Department, seeks for an accommodation to take instructions in the matter. Lists the matter again on 31st of May 2023. Liberty is given to the petitioner to mention the matter for a brief.
Okay.
Come on.
Enough for
Yes, Mr. Rashid.
Well, if there what happened, petitioner is the son of the deceased Dipu Bonia, and he was a teacher Millard, he expired. And during the lifetime of Millard, his first wife
Should not be issued directing them to provide the benefits of DCRG leave encashment, saving fund, insurance benefit area of late Bonia, distant so and so, died on Iman for the petitioner and the respondent number Iman. Set aside and quash the letter dated Iman. And what is this letter business?
Letter
Who are you
like-
first, Mr.
I am
Mr. Rashid?
I am the son of the deceased Mr. Miller.
Father,
Son,
son
son.
of the deceased.
This is son, but teacher.
Deceased.
And the respondent number 9 here, Miller, he is the second wife.
And you have, does the deceased teacher has a wife?
First wife Miller, he is Miller. He was also teacher Miller. She was, but she is missing. So I
Who?
the first teacher, first wife.
Who is that?
That was Miller. I have not made party, but I made a deputation to the authority Miller. Also file a case Miller to the police station.
But Mr. Rashid, the amount of corrections you have done in the petition
My
by
lord.
handwritten, I think you should withdraw and file refresh.
That-
What have you done at page number 5? You have removed the accountant general numbers are being put to it.
Then Miller, I
Wife
may
now.
allowed to withdraw and file for it.
I think better off.
It's Miller.
You said
There's
this
an
properly.
correction is more Miller.
Heard Mr. A. Rashid, the learned counsel for the petitioner, who submits that there are certain typographical errors which would require some corrections to be made. So taking into account the same, he submits that he may be permitted to withdraw the petition and be given the liberty to file afresh. Taking into account the said submission and also upon perusal of the petition, it inspires that there are a lot of typographical errors. And as such, permission is granted, as such, the instant petition stands dismissed on withdrawal. However, the petitioner is at liberty to file afresh.
He has not made the director of pension.
Huh?
He has not made the director of pension party yet.
I'll wait.
See the help Mr. S.R. Borua is giving you.
5,
May please, your lordship. My
Yes.
lordship, matter is covered case, your lordship.
Huh?
Page- my lord, matter is covered case, lordship.
Covered?
Judgment. Yes, lord. Page 76, lordship.
Oh, that one.
Yes, lordship.
Paid the court fee.
Yes, lordship. Lordship,
Yeah, Mr. S.R. Rabha
Yes, my lord.
for BTC.
Yes, my lord.
And who appears? Mr. N.J. Khatuni appears for the secondary education department.
Yes.
It is up to the disposed.
lordship, one thing is that, my lord, paragraph 2, 3, 4, perhaps not necessary.
Huh?
Paragraph 2, 3, and 4, lordship, are not necessary.
Not necessary.
Not. Lordship, kindly,
What?
What is it?
Para?
2, 3, and 4, lord.
What is not necessary?
My lord, in respect of lordship, inspector of school lordship, which was not a matter party in that petition, lord. And the petition was the directed to, the register was the directed to Karati.
What are you saying? I don't get it.
Earlier writ petition lordship,
Ah.
respondent number 6 was not met part.
Ah.
And register was the directed to make it correct in the writ petition.
Earlier you have filed this petition.
Yes, yes, lord.
Then what
Yes,
happened?
This was proper.
These are the same persons.
Yes, lord.
Then why? Means what happened? I don't understand.
My lord, para hard lord. Yes, 81 lord.
Here we are having 4 and 5.
Yes, lord.
Then
And in this judgment lordship, respondent number 6 is there. But in this instant writ petition, only respondent number 4 and 5, lord.
okay. Now here therefore, the order would be that you are to file their representation to the respond number 4
4
and
and
5.
5. Yes, lord. Yes, lord.
Okay.
Yes,
Same
lord.
thing. So here earlier it was 6 was there.
Yes, lord. Yes.
So that is not
Yes,
necessary.
lord.
Mr. S. Ali appears for the respondent petitioners. Mr. N.J. Khatoni appears for the respond number 1 and 2. And Mr. S.R. Rava appears on behalf of the respond number 3, 4, and 5.
Yes, sir.
এইটো কৰি দিবা বাকিখিনি এইখিনিত আছে the council appearing on behalf of the respondent number 3 and has submitted the inspector of school that paragraph number
Yes,
2 is not necessary taking into account that I have made that a para 6 of দিব এইখিনিত ইয়াতে আছে এই আগৰখিনি নালাগে the instant repetition has been taken up from disposal এই পৰহি এটা অৰ্ডাৰ কৰিছো ন এইটো এনেকুৱা এটা লগত কৰি দিব
6,
Obliged.
yes Mr. Honk
Malad, here, Malad, petitioner is the second wife, Malad, and petitioner
not
number
be
2
issued directly and commanding the respondent to incorporate the names of the petitioners in the service record of the respondent number 5 being his legal heir and declare the action of the respondents as illegal and arbitrary. Now, who are you?
and the second petitioner number 1 is the second wife, Malad, and 2 and 3 are the Malad,
Petitioner number 1 is the second wife.
Malad, and 2 and 3
Number 2 is
son, Malad.
son. Number 3 is
Daughter.
daughter. Chalo. Now, who is the person who is number 5?
Well, husband, Malad.
Okay. Now, husband has a first wife.
Yes, sir.
Why will you make the first wife a party? Isn't it necessary? Are you not taking away? You have no right as of now.
Malad.
Your right will only accrue after
Yes,
the
yes.
death.
Malad, Malad.
That is the reason
death,
you
yes,
want. And upon the death, the right will accrue upon the wife.
Malad.
And you want to take away the wife's right, half of it,
Yes, sir. Yes, sir.
without making
Ultimately,
her.
Malad, I am for the minor children, Malad. Ultimately, second wife will not get, Malad.
Huh?
Second wife will not get. Minor children will get. That is the
Minor children, how will they get it?
Malad,
Minor children will get it, but that will happen later on.
Malad. And that may not be also, Malad. If the respondent 5 survive, Malad, till the date of attaining majority by the respondent 2 and 3, Malad, then they will not get, Malad.
Then,
Only for the inclusion of them.
no, she may have a right out there, no? Number
Right,
3,
right.
if she doesn't get married,
Malad. Yes, yes, Malad. That will accrue, Malad.
but she may have a right.
Yes.
But don't you think to make the person concerned a party out there? Not necessary.
Respondent number.
Because tomorrow it will be a difficulty while disposing of the petition.
Yes, Malad.
And if I pass an order to that effect tomorrow, they will come up.
Yes, yes, yes. It will not be so rightly pointed out. Yes, I may be allowed to implement the first.
I think you should
Yes,
file
yes,
a fresh IA or a fresh writ petition. Better off, because you need to, because IA you have to file.
Yes.
After filing that IA, I have
Correct.
passed an order.
Better I
And
will
then-
improve, Malad.
Withdraw
Yes.
and file a liberty.
Yes, yes. Yes.
Or Mr. S. Hope, the learned counsel appearing on behalf of the petitioner. The learned counsel appearing on behalf of the petitioner submits that the respondent number 5 has a first wife.
Right.
And as such, there would be a requirement to implead her to the present in the present writ proceedings. He submits that instead of filing a separate interlocutory application to implead her, the petitioner would withdraw the instant writ petition with the liberty to file afresh. So taking into account the same, the instant petition stands dismissed on withdrawal. However, liberty is granted to the petitioner to file afresh by impleading the first wife of the respondent number 5.
Video. Video.
7,
Yes, Mr. Professor.
Malad, the petitioner has retired from service, but he has not been given pension on the ground that his service was not regularized. But he has served the department, Malad, for more than 20 years as per the office memorandum, Malad, annexer 9, page 54. He is entitled because he has been given the scale of pay on regular basis with all benefits.
You have been given the minimum scale of pay.
No. Regular scale of pay. I've been given the regular scale of pay.
Even without being confirmed.
Yes, Lord.
Right.
Even without being confirmed. And regular scale of pay from more.
How did you get that?
That is, I have been given a service book.
You should also put that also, so that the other persons also should know how you get the regular. People are fighting out there that I have been working for 20 years, 10 years, but they are not giving me the minimum of scale of pay. But you got the regular scale
Regular
of pay
scale of pay.
even without being confirmed.
Yes.
How is it possible? Anyways, very good. You are
It is
lucky enough.
given.
Now, what do you want?
Now, my lord, GPF, they have opened the GPF account. I have got, my lord. Now, my lord, pensionary benefit and the monthly pension that I am entitled to, otherwise, it's not been paid.
In view of that office memorandum,
Yes.
there are two office memorandum. After the 96, you have the 2003. That book, after section rule 153 or something like that, 54 or 51. After rule 151, I suppose, the next page. Mr. Sharma, you are appearing for?
Lordship, Water Resource Department, 1 to 5. 1 to 5.
Or Mr. B. Pukasta, the learned counsel, appearing on behalf of the petitioner. Mr. C. Sharma appears for the respondent number 1 to
5, Lordship.
1 to 5. Mr. A. Chakraborty appears for the respondent number 7, and Ms. D. Decker appears for respondent number 6. Issue notice making it returnable on 19th of June 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 15th of May 2023. The case of the petitioner hearing is that the petitioner have rendered more than
20 years.
20 years of service in the respondent water resource department as a
The Khalasi.
Khalasi.
Work charge Khalasi.
Work charge Khalasi. It is the further case of the petitioner that the petitioner have been all along have been given the regular scale of pay, although not confirmed in his service. The learned counsel for the petitioner drawing the attention to the office memorandum dated 12th of September 1996, as well as, did you get it?
Yes, sir.
What is that?
6 September 2003.
6th of September
2003.
2003, submitted that as the petitioner had rendered temporary service of not less than 20 years, the petitioner is entitled to the pensionary benefits as is available to a retiring confirmed government employee. The respondent shall apprise this court as to why the petitioner would not be entitled to the benefits of the said office memorandums referred to herein above.
Returnable date.
19th of June.
8.
Yes.
The lordship. Petitioner is holding the charge of an enforcement inspector lordship, serving as enforcement inspector.
Suspension.
The suspension lordship. It was suspended on 5/11/2022, but within that period it was not reviewed also.
5/11/2022. You have been suspended.
Suspended. Nor any DP has been initiated, no stock was also.
Huh?
Neither any DP nor any stock was issued after suspension order and not extended also.
Chalo. And you have retired.
No, Lord, I have not been retired.
Mr. F.U. Borguia, the learned counsel appearing on behalf of the petitioner. Ms. M.D. Bora appears for the respondent numbers
1, 2, 3, and 5, my lord, for transport
1,
department.
2,
3 and 5.
and 5.
My lord.
Mr. Where is the government counsel? Yes, Mr. D. Bora appears for the respondent number 4. Why have you made the director of vigilance? What business does he have?
But here in the lordship, suspension order shows lordship. That's why I have made. Where the complaint has been received from Director of Vigilance and Anti-Corrupt.
So,
That's why
so
I'm allowed to.
unnecessarily you
not
making
required.
these people party. You are
Lordship,
also troubling Mr. Bora about with all these things. Okay.
I'm allowed to delete.
Appears for respond number 1, 2, 3, and 5.
My lord.
No, before that. Heard Mr. So-and-so, Miss so-and-so appears for respond number 1, 2, 3, and 5. Mr. D. Bora appears on behalf of the respondent number 4. Okay, let it be there. Why should I? Issue notice making it returnable on when?
As per lordship convenience.
My convenience is tomorrow.
Tomorrow is Saturday.
So we will have it on because it's a suspension matter, no?
My
We'll
lord.
have it on 19th.
My lord. I'll get instruction on the
Yes,
request.
only to the
My lord.
issue notice making it returnable on 19th of May 2023. Extra copy of the petition be served during the course of the day. The case of the petitioner herein is that the petitioner was suspended by an order dated 5/11/2022. It is the specific case of the petitioner that till date there has been neither any departmental proceedings drawn up nor the memorandum of charge of which the charge sheet has been submitted or served upon the petitioner. The learned counsel for the petitioner therefore submitted that in terms with the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary. Now you were suspended. Why?
Suspended.
Because you were arrested.
No, lordship. Here is the case, lordship, on 10 days 2000.
Now where you were arrested?
No.
Where is that order?
Trial of paper. Page 45 is the order.
47?
45.
45. Whereas a complaint has been received by so and so, the governor is therefore pleased to inspector under suspension under so and so. Okay, 6-1. And applies that it is the specific case of the petitioner that in terms with the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary was the Union of India reported in so and so. The period of suspension cannot exceed a period of 90 days. If within the said period the memorandum of charge of which the charge sheet has not been submitted by the respondent authorities, served upon the petitioner by the respondent concerned by the disciplinary authority. He submitted, the learned counsel submitted that on 5/11/2022, the petitioner was suspended, but till date, even after a passage of more than 6 months,
6 months.
nothing has been done. The learned counsel appearing on behalf of the respondent, more particularly the respondent number 1, 2, 3, and 5, are directed to apprise this court as to whether the respondent authorities have served the memorandum of charge of the charge sheet upon the petitioner and as to whether there has been a compliance to the law laid down in the Supreme Court in the case of Ajoy Kumar Chaudhary.
My lord.
Liberty is given to the petitioner to mention the matter properly.
And
The name of PA Assam may be reflected in the clause list and also copy of the
2015 7 SCT 291. Ajoy Kumar Chaudhary lordship was obliged.
copy of the writ petition may also be furnished to us. We have not been, and also name of PA Assam may reflect in the copy.
The registry shall indicate the name of Mr. D. Bora, the learned counsel appearing on behalf of the respondent number 4.
I'm deeply obliged.
9.
Please, your lordship. Petitioner is the wife.
Please unlock the withheld pension in terms with the retirement, decease, direct command to the respondents more particularly for releasing the withheld pension amount at the time and continue the monthly pension. Yes,
Petitioner is the
the
legal
manner
right.
in which you have given the prayer gives me a feeling of the during the time of Shakespeare, they used to talk in these terms. Anyways, tell me.
Let's see, the respondent authority allowed a monthly pension to the petitioner and they received the same. But unfortunately, in the month of July 2022, the pension was stopped by the petitioner. That is the case.
Fantastic. Where is the PPO?
Page 16, my lordship.
Hmm?
Page
You are NPS. You come under the NPS
Yes.
regarding submission of subscriber annuity. Your name is what?
Page number 16, my lordship. Let
Abdullah
Anwar
Bibi.
Hussain Ahmed.
Huh?
Anwar Hussain Ahmed.
Anwar Hussain Ahmed. Date of death invalidation of the NCA 31/12. So and so. Aklima Bibi. Oh, Aklima Bibi. Wife so and so. State so and so. Disability pension amount to be revised by the NCA so and so, 30,000. Monthly annuity. Director application for release of so and so. Okay. Heard Mr. N. Islam, the learned counsel for the petitioner, Mr. Counsel, have you made the director of pension? Who does all these things? Pension is given by the director of accounts and treasury. Have you made them the party? Okay, you're there. Mr. Mr. Arbapudri appears for response number 1. You are also appearing for the director of accounts and treasury.
Copy has not been sub.
They don't know, but anyways. 1 and 4. Mr.
RK Musari. Response
R.K.
number 4.
Musari appears for
Response
the
three.
response number 3.
I'm for 2.
Mr. N.J. Khatoni appears for response number 2. Mr. D. Bora appears for the response number 5. Pension Public Grievance Department is you. 5. Issue notice making it returnable. We want to know why this has happened. Who is going to give us the information? She was getting her pension, the family pension she was getting till the month of July 2022. Thereafter, she has not got. She has submitted a representation, nothing has happened. So who can give the information? This is the BTC place, but why the pension, I think, is given by them? Who gives? Director of pension? Oh, here it is. Directorate of Accounts and Treasury. With reference, I have the honor to submit here with the deceased subscriber information. This is given by the Director of Because I don't think BTC has any role out here. Once the PPO, everything has been done, they can't do anything. This has to be done by these other people. The pension will do it. Mr. Bora, you will do, I suppose. You will inform us.
Respondent number 5.
5. Yes, 5 will be. Issue notice making it returnable on, we get it on 26th of May. 2 weeks. That I'm directing them. Issue notice making it returnable on 26th of May. As the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. You serve it today, not tomorrow, not on Monday.
Okay, today.
Today, to all the respondents. The case of the petitioner herein is that the petitioner was getting the family pension after the death of her husband. But all of a sudden, from the month of July 2022, the petitioner have not received the family pension. being aggrieved, the petitioner is before this court. The respondent number 5 shall apply to this court on the next date as to why the family pension of the petitioner have been stopped. The respondent and the registry shall show the name of Mr. Armud Borpujari as SC Finance and Mr. D. Bora as GSM.
10,
Right? Nobody is appealing.
now 10,
None appears on behalf of the petitioner on call. Let the matter be listed after 1 week.
11,
Yes, madam.
Family pension, madam. Yeah, the petitioner is a widow of a chowkidar, my lord, who had married. Your lordship may kindly see it. She was receiving her, my lord, pension. She has been receiving monthly pension, family pension of rupees 4,091, my lord. And she has made a prayer before the authorities to pay her family pension on revised scale in terms of the 6th and 7th pay committee, madam. And she has made several representations also that have not been considered, madam. And if the representations also, madam, connected C and D.
So in your, how many dates are there in the petition? Only 2. 26/2/2001, date of death, and representation on 12/4/2004.
Yes.
There's no other dates. Okay. So that means you are agitating an issue after 17 years.
No, my lord, she has made several representations, but she did not put any date in the representation. In the representations, I have annexed also, annexure D, there is no date, my lord. But references are there, which shows that she had made several representations earlier, my lord.
Where?
Last page, my lord. That is at page 25. Your lordship may kindly see. Reference my application dated 2/4/2022. Then earlier also on
So
the
you gave the first representation after 2004 in 2022.
yes, my lord.
So why were you
Before
doing
that,
for the
she-
last 17 years?
Before that, my lord, she approached the authorities, my lord, and
How?
made requests personally, my lord.
Madam, you also know, I also know, that is not humanly not possible. With a representation stamped, even a legal notice doesn't work, and you are saying that verbally we have done.
She is an illiterate person, my lord.
Oh,
The widow, my lord.
then
So, my lord,
if she is an illiterate person, she doesn't have the
didn't know how to
resources out there,
approach-
and you mean to say that she has talked to those people? Is it so easy to go to the secretariat and meet those officials?
my lord,
I don't know.
my lord,
Till the time I was on the other side, it was a very difficult thing. I don't know now, but at that point of time, it was a very difficult thing even to go inside the secretary.
but she did not know what is the procedure.
And now you
my
are
lord.
saying she has been verbally telling
She
and
was-
he was assuring.
She was unable to meet, but she made approaches, my lord.
To whom?
To the authorities. Your
Who?
lordship may kindly authorities of the department, my lord.
Which one?
She very frequently she visited the AG office, my lord, and there where she submitted her
whom?
representation, and in the department also, my lord.
Huh? This representation has been sent on 2/4/2022.
Yes, my lord.
So who has written this application?
He has put only thumb impression, my lord.
Hmm?
It was your lordship may kindly.
How
check
did you
thumb
send this
impression.
application? By registered post
Yes, my lord.
to the treasury officer. Now tell me, madam,
Yes.
kindly see page 25. It is to whom? To the accountant general.
Yes.
See the receipt, postal receipt. It is to the treasury officer. See, how is it possible?
My lord, she has furnished me several AD, my lord.
I
receipts,
can't
my
help you
lord.
with this. If the letter is to the accountant general, but receipt is to the treasury officer, how can you help it? Tell me.
My lord, the petitioner also made representations in 2004, my lord.
2004 again to the
Yes,
accountant general.
Yes, my lord.
Where?
Accountant general.
Annexure C. This is not able to be read. Whom it is to be given? Not.
My lord, maybe the receipts, my lord, I have annexed, my lord, wrong receipts because she has.
And kindly see, you
several
are
receipts.
saying that this document is of 2004.
Yes,
Annexure
my
C. Is it?
Yes, my lord.
And then Annexure C continued. You see, it is 2014.
My lord, maybe the receipt is, I have annexed wrongly, my lord.
I can't help you. This petition
Then,
can't
my
help
lord,
me.
I may be
This is
allowed
not the
to
manner in which you file it, madam.
My lord, I may be
You
allowed
have
to
to be.
withdraw, my lord, with the liberty to refile.
This type of applications means it doesn't encourage or have confidence of this court to trust these applications. Tell me, you have a case with it. This court can very well take into account. But where have you mentioned why you could not do anything?
My lord, she has approved the authority in 2004, not 2022, my lord. 2004 at page 23, my lord.
Page?
20.
That is what I am saying.
Yes, my lord, the receipt is has been, this is the wrong receipt, my lord, I have annexed because it is not eligible and several receipts I have in my lord.
At page 21 you are referring to? 22?
23, my lord.
23 is the receipt. There somebody has put it as 12/4/2014. And rest nobody can understand head or tail.
Yes, I think illegible, my lord.
Yes, Mr. Barbulari, can you read anything? What is there at page 23?
No.
Even with, I think you have to use the microscope also. Can't
My lord,
read it.
23 is clear.
Madam, you do properly. This is not done.
I may be allowed to withdraw with the
liberty to file and also give good reasons as to why there has been a delay.
Yes, madam.
S.B. Chaudhary, the learned counsel for the petitioner, Mr. R. Bapujari appears for the finance department. Ms.
Lala for respondent
A.
number
Lala
5. Respondent number 5, accountant.
for the accountant general, and Mr. D. Bora appears for the government of Assam. The learned counsel appearing on behalf of the petitioner submits that in view of there being various formal defects in the writ petition, she would like to withdraw the writ petition. However, liberty may be given to the petitioner to refile. Taking into account the same, the instant petition stands dismissed on withdrawal. However, liberty is given to file a fresh writ petition after removing the formal defects.
12,
Petitioner was the assistant teacher of Borderland Higher Secondary School. She was retired on 31/03/2021, but her pensionary benefits have not been finalized. In this regard,
you retired on
31/03/2021. 2 years have passed.
You have not got pension?
Provisional pension I have got, but
you have not got the final.
Pension I have not got.
Why?
In this regard, a communication was issued by the respondent number 4.
Excess drawal.
Lordship. Kindly peruse page 33, Lordship.
Excess drawal for wrong fixation.
Lordship.
Have you submitted a representation?
I have submitted my representation regarding finalization of my pensionary benefits.
against this? Representation have you given after this 5/3/2022 that kindly don't do all these things. There is a law which has been declared by the Supreme Court, as well as you also have the office memorandum dated 21. What is that date?
14/06/2021.
Fantastic. You know that also. Then why haven't you submitted the representation?
Lordship, I have submitted
Where?
my representation.
Show me that.
Annexure H page 44, Lordship.
Eight.
Simple representation, Lord.
No, don't make this simple business. Because you see, every time you come to the court, why are you not going there? Tell me. If you go there, allow them to say, because now they know the law. Are you not aware?
That poem has been reflected in the communication also, Lord.
Where?
Kindly peruse page.
In that
36.
communication, they always reflect. That is why haven't you emphasized that? See, the problem which arises at this one, 14, this is after Rafiq Masih.
Lordship.
So they know why they have not done it. Why haven't you referred to this? Instead of moving the writ petition, why are you not moving the authorities concerned?
He submitted one representation, but not reflected that poem. Since poem was reflected in
It
the
may
order
be mentioned that while checking my pension proposal for pensioner with some deficiencies arose, and for that matter, my pensioner could not be here. I would like to say that the deficiency as stated above is not occurred because of my fault, for which I could not be penalized. That, sir, I have retired, but till date, my pensioner benefits have not been finalized. That, sir, I request you to kindly finalize so and so. Then why are you not referring to all these things? Tell me.
probably
If you can do it properly and file, or you want to just make the litigations more.
no, Lord.
Because they authorities know Rafiq Masih, authorities know this circular. That if there is, you are an assistant professor.
No, Lordship, I retired as assistant teacher.
Assistant teacher. Now, recovery from retired employee or employees who are due to retire within 1 year or the order of recovery. Well recovered, 18(2). Are to act in accordance with the above stipulation while deciding the cases of wrongful excess payment. Then, in spite of that, if you don't do that, we keep on filing writ petitions after writ petitions. How about issuing a rule that to discourage? I should start from you only.
Lordship,
I should
I have
issue a rule. No, better I'll issue a rule in this. You will come up after 10 years. No, better.
I will submit.
Because you see, you are a lawyer. You have to advise him properly. Why have you moved this writ petition? Yes, there's a court sitting, the court will pass orders.
Means after submitting the representation, he has come to us, Lord. Since he has already submitted the representation, that's why we are before your Lord. It was submitted on 16/2, Lord, 2023. And the order, the communication was of 14/3/2022, Lord. 1 year, more than 1 year past. And representation was submitted way back in February month, Lord. 1 year already passed. Let them take your question, Lord.
I'm getting tired dictating Rafiq Masih. Are the authorities not aware? Karim, asking you, are they not aware? Then
like after that, now this poem has been issued.
who has written this communication by which a person should get this?
Respondent number 4, Lord.
Who is that?
Finance and account officer, Lord. Director of pension.
Director of
Pension. Finance and account.
pension. Yes, Mr. Bora. Are you people not aware of these judgments that if it is the fault of them, not the fault of them, then you cannot do so? Why the authorities are not deciding those? But have you approached the director of pension?
Yes, Your Lord. My representation.
Yes. This representation is to you. Why you have not done it? You have not.
Lordship, sir, name of the Lordship, sir, it has here.
Huh?
Lordship, sir, Lordship.
Right.
About if it's not checking.
So for the fault of the registry, are you going to penalize the petitioner? At the best, you have already penalized the petitioner by not giving him the pension, not following the law laid down by the Supreme Court. So, why does the government does not have a, what you call, seminar? And Mr. Borpuzari should be there explaining to these officials that this is the law. Every time this type of matters keeps on coming, there's no way, end of time. That is why recently the Supreme Court said 70% of the litigations which have arisen is due to the fault of the state. 70%. Didn't they say that? Yes, Mr. Borua, you keep on always appearing for the director of pension. Why is the director of pension not aware of their own circular, of the judgments in the case of Rafiq Masi? Why do you keep there is a requirement of recreation every time? Here is a case that there was a wrong fixation. If there is a wrong fixation, maybe there might be a wrong fixation where, or this wrong fixation at the time he may have been put to notice that we are paying you such. So there must be some things to that effect. So that should have been indicated in the by the director of pension. They have not done that. So if you are just saying that there was a wrong fixation of his scale, then he does not fix the sale for himself. The payment has been made by the authorities. The fixation of pay has been made by the authorities.
Because proposal has to be come at the right scale, Lordship. So we say whatever anomaly detected in our directorate, we send it to the concerned department, Lordship, that this has happened. So after correction, they send a fresh proposal because we have to issue the pension only at the correct pay scale, Lordship. That has to be determined by the department, Lordship, that along with the proposal.
So the departments are not aware. Now there is a government circular of the finance department for the purpose of, where is that document?
Lordship, annexure I page 45.
Yes, page 36. Excess dwell may be assessed with the due and gross expense duly certified by the HOD regarding whether there was any fault on the part of the pensioner so that the matter can be forwarded to the competent to waive recovery in terms of so and so. So it has been categorically mentioned by them. Then why have you approached them, not them, the director of elementary education? Elementary. Your representation is only to the director of pension. How? They have already done it.
This letter was sent by the respondent number 4.
Which one?
This was from
page 36.
Lordship.
Understood. So it is in the hands of whom? The inspector of schools.
Lordship.
To whom have you submitted the representation?
The director of pension.
Why? They have done their duty. Unless the inspector of schools does not do it, or the director of elementary education does not do it, how can they do? Why there is no representation to them?
The director of pension is a authority regarding pension.
They have done it. That you have to give us a fresh proposal. They don't have the mandate to correct the proposal. No, they don't have that. The proposal has to be sent. Now the proposal, if it is incorrect, they will only ask them that this is the deficiency, kindly do that. And for that, they have already done it on 5/3/2022. Who is the authority who has not done it? The elementary education department. Why haven't you approached them and approached this court?
Lordship, the letter was sent by the respondent number 4.
Who is the respondent?
That finance and account.
That is the director of pension. They have written to the inspector of schools to give a fresh proposal. Now, who has not done it?
Like elementary, secondary education.
So, whom should you have approached?
You approach the director of
Then, no, you have to approach the director of elementary or the inspector of schools. Why haven't you approached? It's easier to file a writ petition.
No.
Then we will issue notice. I will issue notice, do everything. But cost is upon the lawyer. You have to pay the cost. Every day there will be a cost. You keep on paying. Because it is at your behest this has happened.
Any other I have obtained on inspection whether she had approached the inspector of schools or
she is not. As it appears.
after repetition it appeared.
So you should have advised him to approach the correct authority. When the matter came, why did you file the writ petition immediately without approaching the authority? You have seen only the director of pension. Director of pension have done their duty. Then
Any other that whether she has approached the inspector of schools or
what instruction? Subject to cost to be imposed upon the lawyer. No. It has to be done because this is an irresponsible writ petition. I'm not saying the petition is irresponsible. I'm saying the lawyer is irresponsible. You should have done it. How many years of practice do you have?
6 years.
Huh?
6 years.
Then 6 years is a lot of time in the legal way. Then why haven't you advised that look here, you just submit a representation and then come after 1 month, we will look into it. If they should have been done, something would have progressed. Or it is easier for that instead of filing or issuing a representation, why not get the representation issued through the court by issuing a notice?
No, Lordship, I think fact is there. Since pension is to be finalized by the director of pension.
Understood. Director of pension, tell me, Mr. Counsel, can the director of pension finalize it if the proposal is wrong? They don't have the power to correct it unless you tomorrow contest the election, change the rules of there. They don't have the power to correct it. Even if there is a deficiency, they will ask the department to approach the finance for waiver. There is a particular process by which things work. Otherwise, this person concerned, if he does it, tomorrow he will be called for disciplinary inquiry. So we will issue notice, cost upon you every day of 10,000 rupees.
Lordship.
Yes, every day. Na? How many lawyers are there? How many lawyers you have been put to difficulty? Everybody. Why should the state pay for this matter?
Let me take instruction.
No, that can't happen. It has to be borne. The cost has to be given by you.
What is then?
Every day, their fees, you have to bear it from your pocket. Then only things will improve.
Lordship, then I may be allowed to file after some time. Before that, I may be allowed to approach the concerned authority.
I may be means you or the petitioner. Then you have all the petitioner already has paid you for all these things. Like she has come out here. She's a particular person who is retired out here. Instead of all these things, you shouldn't have done that. She's a retired person. Again, you are going to file. See what is the problem which is being faced by the petitioner because of you. Okay, for the first time, put him in the black book. We are again in the black book. So next time, don't make such mistakes. Heard Mr. P. Wardlow, the learned counsel for the petitioner. Mr. SR Bolua appears for the respondent number 3.
3 and 4.
Mr. NJ Khatania appears for the 3 and 4, na?
1 and 5.
1 and
5, my lord.
1 and 5. And Mr. R. Babujari appears for the respondent number 2. Issue notice, when can you get it? Instructions? Because this is a case why a person, this was given in 2022. Why have you been sleeping out there?
2 weeks, my lord.
2 weeks. Else, think about 197A. Yes. Issue notice making it returnable on 26th of May 2023. As the respondents are duly represented, extra copies of the petition will be served upon them during the course of the day. The case of the petitioner herein is that the petitioner retired on
31/03/2021.
31/03/2021 as the assistant teacher in Bordoloni Higher Secondary School upon attaining the age of superannuation. The petitioner have been in receipt, thereupon the pension, thereupon the papers pertaining to pension were duly forwarded to the Director of Pension by the department concerned. It is relevant to take note of that petitioner is presently receiving the provisional pension. However, the petitioner till date have not received the final pension as well as other pensionary benefits. It is further seen from a perusal of the petitioner that the respondent number 4 had issued a communication on 5/3/2022, wherein a deficiency has been mentioned to the effect that pay on upgradation of the promotion to the graduate scale should have been fixed at the stage of rupees 1555 on 1/1/1994, and the subsequent fixation of the pay in revised scale on 1/1/96 should be fixed at the stage of rupees 3940 without any weightage benefit, and further regulation of pay up to the date of retirement has to be done accordingly. It was also mentioned that as the incumbent had availed the fixation benefit on 1/1/1994, the same to be treated as one promotion, and she would be entitled only for 2 ACPS/MACP benefit. In view of the wrong fixation, which was pointed out by the respondent number 4 to the respondent number 5, a request was made for making correction, for submitting a fresh proposal after making necessary corrections. However, nothing has been done till date as per the petitioner, and as such, the petitioner has approached this court. The respondent in the elementary education department shall apprise this court on the next day as to what steps have been taken by the respondent number 5 in pursuance to the communication dated 5/3/2022 issued by the respondent number 4. Liberty is given to the petitioner to mention the matter for updating.
But if GA Assam name may be shown in the cause list.
Huh?
GA Assam name may be shown in the cause list.
Mr. S.R. Bolwa's, the registry shall show the name of Mr. S.R. Bolwa, the learned counsel for the
GA Assam.
Secondary department.
Secondary.
Secondary department, not elementary.
secondary department. It is secondary. 4 and 5.
Item 13.
Yes.
Here, Lordship, the petitioner's service was terminated only because a criminal case is pending over him for more than a year. And that is the only reason for which his service was terminated by the bank. And they have mentioned that the criminal charges derived against him, which is violation of code of conduct, immoral act as per clause 20.5 of the external maintenance of the bank. Their regulated.
So you are appointed as branch
the-
head at Ben to grade manager.
As the,
By Northeast Small Finance Bank.
Yes.
Then what happened?
Then, Lordship, he was given the appointment later on 30/10/2019. Then later on, he was suspended on 26/8/2021, saying that the state arrest has been made on the POCSO Act and suspension was made against him. But without giving any other further notice to him, not giving an opportunity to him, his service was terminated from on the date of 21.
Where is the termination order?
Termination order is at page 23. Page 23. Same case is still pending in the court of Meghalaya, Lordship, and it is the 22 page is the certified copy of the present case, Lordship, where the case is still for evidence sake, and he has also filed a representation on dated 21/12/2022 before the Small Finance Bank where the termination letter was issued, and also a legal notice was also being sent on 06/3/2023.
Now tell me, what is this Northeast Small Finance Bank Limited?
This is a bank under this is a private bank, Lordship. And
how a REIT is maintainable?
Because Lordship, the termination that has been made is based on the fact that the criminal case is pending against him for more than a year.
No,
And the
understood.
same
It is absolutely wrong. Let us assume. But how is a REIT maintainable?
because if a case is pending before him,
Everything, Mr. Counsel, I understand everything. That if you see from the appointment order also, your employment may be terminated forthwith if you are held guilty of any offense involving moral turpitude.
Yes.
But found guilty.
Yes.
You are yet to be decided to be guilty. Understood, very well. But the question out here is, how is a REIT maintainable?
On the spirit of justice, your lordship.
No. On the spirit of justice also, why not the civil court? You are appointed by a private company. So how is a REIT maintainable out here?
Because his fundamental right has been infringed.
Fundamental right against what? What?
Because he has no other source of income also, lordship.
No other source of income, whatever may be, it is a different aspect of the matter. I Are you saying that any person out there can, tomorrow, any person out there in the government servant, or not a government servant, any person, you are working out there in some shop out there, are you going to maintain a writ for that if you are terminated? No. How are you maintaining a writ in respect to a bank, private bank?
But they are regulated by the rules and regulations framed by the Reserve Bank of India also.
They are regulated for other purpose, not for the purpose of the terms and conditions of the salaries and all, or the terms and conditions of employment. That is not the subject matter of a matter pertaining to a private bank.
But a quick and adequate result will not be found in the civil court, Your Lordship, if the writ petition is filed and notice been issued. Some purpose may be served against him,
How?
Your Lordship.
How that is possible? Isn't it the case where you have to go for asking for damages if your contract is otherwise terminable in nature, unless you get the benefit under 311? Isn't it your contract terminable in nature, determinable in nature? If it is determinable in nature, can you initiate the proceedings for enforcement of the terms of the contract? You may be at best be entitled to damages for wrongful termination. And if you can't do it out there in the civil court, can you do it by way of a writ proceedings? This court doesn't have the jurisdiction under 226 against those. Yes, it would happen tomorrow that if tomorrow this Northeast Financial Bank out there has done some fraud or done something to that effect, whereby it is affecting the public, then a writ would be maintainable. But it is an employment in the services of a bank. Can it be maintainable?
My fact was that the Lordship, because the termination is based on the fact.
Absolutely, I understand you have a good case.
Yes.
But if a contract is determinable, this is a contractual appointment. If a contract or terms of employment is out here, is not a statutory appointment. It's an appointment as per the contract. So they have given you a letter of appointment to that effect. And you do this, you have to give it 3 months notice to throw you out and all these things. Very well. If it is done wrongly, we're entitled to damages, nothing more than that. Wouldn't this come within the ambit of a contract of personal service? Think, I'll give you some more opportunity.
Yeah, okay, I can answer that.
But because you see, issuing notice out here,
yes,
and any decision, because at the end of the day, this court can't, it doesn't have the jurisdiction out here. It will be useless for futility because the question of staying does not arise once a termination order has already happened. So think about it. I'll have it on some other day. And there's a recent judgment of the Supreme Court in St. Mary's something. Just find it out. I think 2000. The St. Mary's matter, what is that? Employment. The Supreme Court has delivered. Although there was a question of right to education and all these aspects were brought in, but the Supreme Court said nothing doing. This is absolutely a contract between the private institution. So nothing to that effect. What was that? I forgot. Look into it. I think it's in 2020 or 21, Supreme Court. Or Mr. S. Ahmed, the learned counsel for the petitioner who seeks an accommodation in the matter, let the matter be again listed on 19th of May.
Apply.
14.
May I please, Lordship? Matter pertains to non-disbursement of the pensionary benefit. My lord, so there was a clear order from this honorable court at page 62, my lord. starts from 62. The operative part is at page
And
6.
dispose of directing the commissioner and secretary to the Department of Health to consider and pass a reasoned final order on the letter of resignation of the petitioner so and so. If the resignation of the petitioner is accepted, it will be deemed that it has been accepted from the date of the letter of resignation and submitted, and consequently be provided to the petitioner. If the commissioner is of the view that it is not accepted, a reasoned order be passed and be communicated to the petitioner.
Yes.
Okay, now,
My lord, thereafter a speaking order was passed at page 80, my lord. The relevant portion.
and no outstanding were detected against him in the medical. It is seen from the personal hearing was conducted as well. I was absent on the date of hearing without any member. I was on remand after a lapse of 2 months from the date of submission of the petition. He with the notice and we to submit it. Accept the recognition with respect of human will be liable to clear outstanding due to emergency. This order is issued in person. So your resignation has been accepted from 2/1/2021.
Yes, madam.
Now you have not been given the pension.
Yes, madam.
Even the provisional pension.
No, madam. It is covered under, my lord, the new defined pension scheme. It's different.
Now, doesn't the new defined pension schemes and besides provisional pension?
No, madam. No. But regarding the withdrawal of the terminal payment, my lord, the guidelines are silent, as in the new defined contribution pension manual.
Yes, tell me.
My lord, the guideline,
no,
as para 38.
No, Mr. Counsel.
Yes,
as per you are entitled to the death cum retirement benefit.
Yes, madam.
Because by way of a communication dated order dated 1/2/2021,
yes,
the benefit of the death cum retirement benefit which has been given under the old pension scheme has also been given to under the new pension scheme.
Yes, yes, madam.
So you are aware of that.
Yes.
So that is one of the things we are asking. Now, disperse forfeit release, disperse the pensionary benefit, gratuity earned, leave encashment. Leave encashment.
Earned leave encashment. My lord, they are not paying me the earned leave encashment also. Gratuity even. I am entitled for the gratuity also as per the gratuity act, my lord.
2 advance increments since the job of so and so. Okay. Okay, no health department. No, yes. Why? What has happened?
But your name has not been shown, Lordship. That's why I made the matter, Lordship. HC Health.
Have you served copy of
Yes, yes, my lord. Name has been shown because nowadays it's renamed as Medical Education and Research Department. Personal Health and Department has been renamed.
So now it is being shown as Medical
Education and Research Department, my lord.
SC Medical. It has been shown as
SC Medical.
That's why I missed the matter.
Yes, yes. Yes, sorry.
Mr.
PM Dakar.
PM Decca, the learned counsel appearing on behalf of the petitioner. Mr. D. Upamanu appears on behalf of the respondent number 1, 2, 3, 4. Mr.
And
Arbapuzari
9.
appears for the respondent number 5, 6. Mr. C.S. Hazarika appears for the respondent number 7. Mr. R.K. Talukdar appears for the respondent number 8. And D. Upamanu Agot, 9. issue notice making it returnable on 21st of June 2023. Steps be taken upon the said respondents. As all the respondents are duly represented, extra copies of the petition be served upon them by 15th of May 2023. The case involved in the instant writ petition is that the petitioner have not been paid his pension, paid his pensionary benefits, gratuity, earned leave encashment, 2 advance increments since joining of the job, area due, entitlement under the 7th pay commission till the date of his resignation, and other benefits. Though the petitioner have been deemed to have retired on 2/1/2021, as could be seen from the order dated 17/11/2022 issued by the Commissioner and Secretary to the Government of Assam, Medical Education and Research Department. The respondents in the Medical Education and Research Department are directed to apprise this court on the next returnable date as to why the benefits to which the petitioner have claimed have been withheld. The same shall be done by way of filing an affidavit by 21st pictures, 23rd June, by 19th of June.
Much obligement.
File your affidavit.
Admission item 15.
I have to answer the affidavit filed by them. I have to answer the affidavit filed by them, the respondent. So I may be allowed 3 times further.
Why?
Some personal difficulty if the petitioner could not turn up.
Oh, you have filed some affidavit. What is this affidavit business?
Government file.
Yes. Is he entitled to the area salary?
No, my lord.
Why?
Because his initial appointment was illegal appointment, my lord, against non-existent post. Then, my lord,
when did you find out?
In 2012, we find it out, my lord. And my lord,
did he get some salary?
Yes, my lord.
Up to 2011. Up to 2011, February 2011,
you got your salary.
Yes. But thereafter, the screening committee was constituted, and he was subject
to that order.
Yes, my lord. And he was subject to the screening committee. In fact, he did not participate in our affidavit. It is a stand of that he did not participate in the screening process, my lord.
Now, if he have not, what is his age now? 43 at the time of filing. Now it will be another 7 years.
Yes.
Which means it will be 50. Now tell me, you have 4 categories.
Yes. Okay.
He may come within the ambit of not recommended but working. Are you still working?
Yes. Okay.
Working. So you will come within the ambit of that 8,470 teachers.
Yes.
Now, pursuant thereto, you had made 3 lists.
Yes.
One is the person who received salary till 2007 and had the degree qualification. Second, a person who had not received the salary, received the salary, did not have the qualification. And the third is who did not receive any salary in here.
Not
why the petitioner has not been brought in within the one and two?
Because during the he did not participate in the screening process. We could not find any record of the petitioner that he participated in the screening process. So his genuineness of appointment would not be ascertained, my lord.
So he initially, when the advertisement was made in 2011-12, he did not participate.
Did not participate, my lord.
Did you issue notice to him?
In fact, my lord, Annex B of my additional affidavit, my lord.
Yes, petitioner.
Annex D.
Page?
Page my lord 51.
What page 51? Annex B? No, it can't be. Your additional, there is Annex C only, or in estimates? Annex B.
B, transfer copies in.
Application regarding presence for verification of year. With due respect, it is to inform that on so and so a verification was held at the circuit hall wherein I was present with all my documents and my documents were verified. It is for your kind information. Yes, then?
So he claimed that my lord, he appeared in the verification process, but we don't have any record.
How did you get this document?
This document he submitted to the Deputy Inspector of School Nazira, my lord.
Understood.
Later on he submitted a.
When?
In 2016. In 2016.
And the verification process was going on
2014. Yeah, in fact,
so that means you issued notice to him.
Yes, my lord.
Those notices were issued sometime on 4/11, 4/1 or 1/4/2014.
Yes, my lord.
But you don't have any records.
We don't have any record. And pursuant to that, my lord, we have passed a speaking order on 1st of April 2023, page 53, rejecting his claim, my lord, for area salary, my lord. Annex C, page 53, my lord.
Findings. Thereafter, the education proposed the constitution of a screening committee, amendment, so and so, so and so, so and so. In response to the aforesaid advertisement, applications were received from such categories after conducting so and so directors, the elementary also 5 screening committees, so and so approval was sought for accommodating those which were received so and so. Stated that the names of the petitioners so and so does not appear in the list of such who applied against the aforesaid advertisement as per the office of the Departmental. On the other hand, they himself submitted one application stating that he submitted documents to Sumaya for Sagar and also the above where the petition name did not appear in any of the list prepared out of the screening committee report pertaining to Sagar district. Therefore, he could not be accommodated in any of the tutor teacher. Now, how can this court ascertain whether it has been submitted or not? Tell me.
I will take it back to the
Problem arises there. Although you had that case, if you had submitted, because as per what they have done, they are only if you were still working. Have you enclosed any document to show that you are still working?
No.
That is the main document. Why haven't you enclosed that?
Not if I may be allowed 3 weeks time so that I can take this impact. The matter of 2016.
That is why. 3 weeks, no. It would look nice if you ask for 3 days. 3 weeks is too long. This matter, 2015 does looks nice, no? But you could have been brought with it. Did you have the training?
Yes.
Had the junior basic training also.
Yes,
then you could have been a teacher.
Yes, otherwise,
Category 1.
if he participated in the screening process, outcome will be different, my lord, otherwise.
Now, in the advertisement which we are issued, so you said that you must have issued a notice to him. Did you issue a notice to him?
That notice, my lord, I have not annexed with the additional affidavit, my lord. But obviously, during that time, my lord, whoever participated in who have submitted the application, my lord, we have issued notice to them.
No, I'm saying why. Or in the advertisement in the month of in 2011-12,
yes.
when you asked for a, did you say anything that if you don't give it, your right will go? Because why I'm saying it, if we apply the same yardstick, unless you have put him to notice that if you don't do it, why the petitioner should not get the benefit? Because he was getting all the salary till 2011. And therefore he comes within list 1 and having the junior basic training. Why he should not be accommodated by waiving all his earlier dues? If you have put that in the advertising.
I think there's no fixer in that sense, my lord, in the advertisement. I have the, right now I don't have the copy of the advertisement, but otherwise I have, my lord.
Now, because if it is not there, would the petitioner not be entitled to basic, to an appointment similar which you have given on 31/2021? I hope you would be okay with that. You are 50 years now.
In fact, my lord, I have been told by
Because
the
if I remember, as I was taking up that matter,
Junu das.
Yes. That judgment it has become a very long judgment later on. Now that judgment I have dealt with these aspects of the matter. And the only consideration for taking those people who were not recommended and were working was only to the effect that they had received the salary.
At some point of time, they have received.
No, received the salary till 2007. You have put the cutoff. But here is the case who has got till 2011. But if you have not put him to notice that if you don't participate, you would not be getting anything.
Because that was not there in the advertisement, because my lord, this cabinet decision was taken later
Because
on,
you
my
did
lord.
not issue the second letter. Now, in this case, you have to also take note of that initially before this list 1, 2, and 3 were prepared, which was done and then sent it to the cabinet here. There was a decision to issue a show cause to everybody why they should not be terminated.
Yes.
Or why they should be entitled to any salary or anything to that effect. But that was not, that process was not gone into. Then can the petitioner be brought within that act?
In fact, my lord, I have been told, my lord, that in Sibsagar district, there is due to there are some more than, my lord, 200 or 300. They have not participated in the verification process. That's why the governor now decided to re-verify it. I have been informed by the department, my lord, that that process is also
Going on?
They have started, my lord.
Then the petitioner can submit.
Exactly, my lord.
You get your instruction on this. Huh? Because that is a very relevant thing.
Yes, my lord.
Then the petitioner can, because otherwise the same yardstick applied, the petitioner
Yes,
should
my
get
lord. Yes, my lord.
at least his post from in the month of the from as a teacher.
Yes, my lord.
As he had this training out there. Heard Mr.
T. Bullock.
D. Borua. The learned counsel T. Borua.
T. Deposit.
Okay, D. T. Borua, the learned counsel for the petitioner. And Mr. N.J. Khatania, the learned counsel appearing on behalf of the Elementary Education Department. The learned counsel for the Elementary Education Department had submitted that they have already filed the affidavit in that matter. And the learned counsel for the petitioner seeks for an accommodation so that the reply can be filed. Be it as it may, that while hearing the matter and upon perusal of the materials on record, it appears that the petitioner herein claims to have received his salary till the year 2011. The petitioner further claims to have the junior basic training.
Yep.
It would also be seen from the affidavit, additional affidavit filed by the Elementary Education Department. That pursuant to an order passed on
Two, 2010, my lord.
2/3/2010 by this court in WPC number 1048/2004. The Education Department of the Government of Assam constituted a screening committee, constituted 5 screening committees.
Yes, one screening committee, my lord, but the work was divided into divisional committee, my lord.
Screening committee to examine the cases of illegally appointed teachers, so as to take a decision for regularization and entitlement of salary or otherwise. In pursuance thereto, advertisements were issued on 1/2/2012 and 4/2/2012 in the local newspapers. It is relevant to take note of that such advertisement is not a part of the additional affidavit. Be that as it may, 12,085 numbers of applications were found in order and was submitted to the government for final verification. The Elementary Education Department thereafter issued another notification constituting 5 screening committees headed by the divisional commissioners concerned and the principal secretaries of the 6th schedule area and the BTC to examine these applications and the report of the preliminary committee. The 5 screening committees, upon making verification and subsequently another re-verification, identified 4 categories of teachers. Category 1, that's recommended and working till date 136. Category 2, that's recommended but discontinued jobs, that's 250. Category 3, not recommended but working till date 8470. And category 4, not recommended and discontinued job, that's 2,900. In respect to the category number 1, those teachers were regularized. As regards the category number 2 and category number 4, the question did not arise for regularization, taking into account that they have left their jobs. However, as regards the category number 3, who were not recommended but were working, the government took a decision to issue show-cause notices to them. While the said issue was pending, there was a meeting between the Minister of Education along with the Association of the Irregular Teachers. On the basis of such discussion, a decision was taken to solve the problem of those irregularly illegal teachers appointed, subject to the approval of the cabinet. Accordingly, a departmental committee was formed by the government to verify salary status and qualification of those category 3 irregular appointees. Three lists were prepared. List number 1 were those teachers who got their salary up till 2007 and had the qualification of JBT oblique D.EL.ED, E to capital, L to small, E to ED, E to capital, D to small.
Well, it is not till 2007, my lord.
It is not here. There's another one. Not here, you have not done it. You want to see that? I mentioned it.
Well, in the cabinet decision, my lord, maybe as at page 48, my lord. List number 1, the teachers who have received salaries at some point of time and having fluent.
Yeah, you see, then one, approval sought for accommodating those teachers who received salary up to 2007.
Yes, my lord. Sorry, my lord.
At least those judgments where I deliver, I remember those things. List 1 where those teachers who have received their salaries at some point of time and having, where those teachers who received their salaries up to 2007 and we're having the JBT oblique D.EL.ED. The number, in that list, there were 1574 teachers. List 2 were those teachers who received salaries at some point at up to 2007, but did not acquire the professional qualification before 2011. And as such, they were to be accommodated as tutors. In such list, the total number of teachers found was 2960. List 3 were those teachers who neither received salary nor qualified the training. That is JBT oblique D.EL.ED. In that category, there were 7250 teachers. It is further seen that the cabinet, in its decision dated, the cabinet approved the said proposal on, what is the date?
2010.
2020.
2010. 2010 or 2110?
2010, 2020.
The
And
cabinet,
31/1/2021 is the appointment.
no, that I know.
Cabinet gave its approval on 7/10/2021.
710.
Page 54, 7/10.
Pursuant thereto, those teachers in list 1 and list 2 were duly appointed as teachers and tutors respectively by orders dated 31/2021. 31 or 30?
31/1.
31/1.
No, sorry, 31.
30.
30, my lord.
In the instant case, it is received from the additional affidavit that on the ground that the petitioner application was not found, though the petitioner have received salary till 2011 as well as had the qualification of the joint basic training, junior basic training, the petitioner was not accommodated in terms with the cabinet memorandum dated 7/10/2000, cabinet decision dated 7/10/2020. While further hearing the matter, the learned counsel for the elementary education department further submitted that there is a further process, further verification process is going on in respect to the Sibsagar district, where there were certain teachers who were left out. It may not be out of place to mention that it is the specific stand of the petitioner that the petitioner had submitted those documents before the screening committee on, what is the date? 23/9/2014. Be that as it may, the learned counsel appearing on behalf of the elementary education department shall obtain the instructions as regards the present verification process and as to whether the petitioner can still participate therein. You are at liberty to file. I don't think nothing is required for you to file. I have mentioned it. You could have filed only this one. Is the matter well? Full matter.
After 10 days,
Yes. Have it on 24, 26. You want to file your affidavit, file it. But I don't think it.
Earlier occasion, was supposed to please the director, Departmental authority file affidavit by
yes.
4th of May. Also giving opportunity to ask and reply, my lord.
You have filed?
Reason, maybe, my lord.
I have filed.
But they have filed, you have received, my lord.
Pursuant to the appointment orders being issued, the petitioner number 2, 3, 5, and 6 have already joined by submitting here. However, the petition number 1 and 4 having not accepted the appointment orders, MU appearing for the request to submit that you would like to take instruction in the matter. Yes, what is your instruction?
So, my lord. I mean, my lord, sometime file reply, madam. We have received the copy, they have filed, madam. They were putting yesterday. Because
This happened on 10/4. We are into date 12/5. The matter of 2017.
So, they have filed the reply after
If
6
you have
years,
not
my lord.
accepted it, this court can't give you a declaration to the effect that your appointment is right because there is already a verification committee who have stated that.
We have challenged the report of the screening committee, my lord. I mean, we are allowed to file the reply, madam. Because
You
we
have
have
challenged?
received the copy.
Have you challenged the screening committee?
Yes, sir. We have received the copy a day before yesterday, my lord.
Which one?
They have filed the reply, my lord. Direction was given to file by 4th, my lord. Due to some reason, maybe some delayed, my lord, filing, my lord.
They have filed an affidavit.
Yes, my lord.
We have filed on 8, my lord.
8,
Okay.
8, my lord. So, my lord, I need some time to respond on
not
this, my
there.
lord. And
Heard Mr. MU, I'm the learned counsel for the petition. Mr. N.K. Khatuni appears on behalf of the elementary education department. It has been brought to the notice of this court that the elementary education department has filed an affidavit on 8/5/2008. The learned counsel for the petitioner seeks an accommodation to file a reply, taking into account that the matter pertains to the year 2017. This court fixes this matter again on 31st of May 2023. In the meantime, the affidavit
because maybe some maybe humbly submit, well, because, my lord, there is the expiry of
this court is sitting in this bench won't help. This matter we will pick it up.
my lord, I
File
need
your
some instruction and some documents from all the teachers, my lord. The wife of the respondent number 1, my lord, expired, my lord.
Only
Wife of the respondent number 1 is sorry, petition number 1 is expired.
no, I'm not on that. One, we are only concerned with one. Others have already joined. Others have accepted everything. Others can't have a claim. It is only in the case of petition
So,
number
my lord,
1.
this is the inequality bargaining power, my lord. They have joined, my lord. They have,
Then you are.
they have
How
done
can
that
you
20
challenge
years
that?
of service, my lord.
No, how can you challenge that aspect?
20 years
Don't
of service.
accept it. You are challenging it. You want to challenge it, which 1 and 4 wants to do it, I'm hearing it. But what about others? Others have no
They
business.
will, I will file the reply, my lord. I will file the reply, my lord.
You file
Only
it by
need some time, my
31st.
lord. We have to collect some documents, and all the teachers are scattered in different remote cases of the Chittagong district.
First of all, therefore, you should not have filed all the matters with all remote people all 31st of May.
Obliged.
17.
Matter of potential or non-payment of area salary.
Mr. PJ Soikyapar, good for you. That client of yours whom you left the case,
My lord.
you have his number.
No, my
How did you file this petition?
lord. The husband was there, my lord. Since husband expired, my lord, thereafter there is no communication.
No. Your case was specific that you did not get the family pension.
Right.
Meaning thereby the husband was dead.
Yes.
So how can the husband be there at the time of filing the petition?
Earlier, my lord, Susmit Kandula, the husband, my lord. He has
Whatever may
contacted,
be, but when your filing of the petition is that as the family pension has not
My
been
lord.
done, meaning thereby the husband must have expired.
My
So
lord.
how can he be present at the
First-
time when you are filing
The
that?
son was contacted with me, my lord. Son, my lord.
You have the number of the son.
No, my lord. He has changed the
That
file.
is the
He-
biggest problem because you have not advised the client, your client
I have
properly.
written a letter to the, my lord, the person concerned.
No, the question is this. They should only have been advised out there to submit an application before the treasury officer to get it, which has not been done. Isn't that Mr. Dhar? Remember, they have got Mr. Saikia. That matter. I made you an amicus.
My lord, my lord. I have already
The only thing which is required is to file a representation before the
Before the-
treasury officer. Nothing else.
nothing else.
But we don't have anything out there.
They have returned.
How did you recuse? If you have returned it also, that is why now it will be made a mandate that without putting the phone number of your client, the petitioner is in the process. Email address and everything, you can't file the petition or even the affidavit in opposition. It will now, it's coming up in another 2-3 weeks. Will be coming. This is the reason, primarily. Now, she has only to be informed only one thing, that she should file a representation before the treasury. And without doing that, you have filed this petition, and that is the problem which is happening. Everybody is saying that she is entitled, but how do I communicate? You can't leave the matter halfway.
Since they must take back the file, my lord.
So you should have put the phone number or something out there. Without doing that, why have you done that? That is the problem. Now I can't dispose of the matter. I can't dismiss the matter being a pension matter. It's all because of this.
I'll
And the
try.
trouble I am giving to Mr. Horford.
I will try.
Yes.
This matter, my lord, pertains to my lord, non-payment of area salary from 14/7/2011 to 20/10/2012. my lord.
Yes. Any information, finance?
Area salary, my lord, these are all delegated powers, my lord, to the administrative department. When the calculation, everything has to be made, my lord, by the administrative department. On the last occasion, my lord, it appears in the from the last order, finance was newly impleted. Perhaps we have not been served with copy of the petition.
Notice was issued upon the respondent number 2 by registered post with DT with the Commissioner Secretary Finance Department. Neither AT card nor reserve. No, Finance Department is already a part.
No, it is already a party. Perhaps we have not been served with extra copies, my lord, because I don't have the file today. That is
No,
one
Mr.
aspect.
Solia was there on the last occasion.
Yes, Soliha was there, my lord. I have also inquired with him, my lord. We have the files.
Have you
otherwise-
served the copy?
My lord, have.
Where's the receipt?
These are area salary matters, my lord. Area salary.
18/4/2010. 18/4/2010.
18?
4, my lord.
It can't be. On 19/4, I asked you to pay.
No, this is received by on behalf of education, Rajesh Kutumbar, not by finance.
and then I'll submit.
It appears on record that in spite of a clear categorical direction given on 19/4/2023 to serve a copy of the writ petition upon the Standing Council of the Finance Department, the same has not been done till date. The same be done
Today itself, Maharaj.
expedition.
All right.
List of the
I'm obliged, my lord.
18.
May I page, your lord?
Yes.
Lordship, matter pertains to non-payment of salary, your lordship.
Yes, non-payment of salary.
Salary, fixed salary, lordship.
What salary?
Fixed salary.
So caused by his fixed salary for 24 months. Pay the fixed salary of the minister for 24 months amount in being unpaid salary. From whom? You want the money from whom?
From the respondent, your lordship, Assam University.
Are you asking the Ministry of Science and Technology? Or
Assam
University
University,
Grants
Silchar.
Fund Commission? Or the Assam University Silchar?
Assam University, Silchar. Kindly see, lordship, page 15, lordship.
Page
15.
and 5.
In reference to your letter dated 12/3/15 addressed to Honorable Vice Chancellor, I am directed to inform you that the amount will be released as soon as we receive the grant from GBT.
What is DBT?
GBT lordship,
Who is appearing for the respondent Silchar University?
Respondent number
No, who is appearing for the Silchar? Nobody. Has anybody appeared for respondent number 3? Respondent.
respondent on last lordship, last order, your lordship.
If the respondents are not beyond make the digital court shall proceed with the matter in India. Assam University, Silchar, Central University.
Silchar, Assam University.
Release of the remaining grant related to the who has filed this affidavit? You have
Lordship,
filed
this is
affidavit,
petitioner's
trustee.
affidavit, trustee. Respondent number 5.
There is an affidavit, there is a petition. But they received it.
I refuse to receive, lordship. Respondent number 5.
Show me your entitlement. How are you entitled?
Lordship, kindly see, lordship. Page 10 is appointment.
Reference to your letter dated 12 addressed to the Honorable Vice Chancellor. What is the amount? Where is your letter of 12/3? Yes.
12/3, lordship,
So I
page.
got 5 for your client. Now show me your appointment order.
Page 10, your lord.
Huh?
Page 10.
Hey?
10. 10. Appointment, appointment as laboratory assistant in GBT. GBT lordship, Department of Biotechnology.
You have
Next.
Madam, you are appearing for UGC? Kindly come here. I can't hear you.
Lordship, UGC, respondent number 2.
Now, this particular project, is it project project is still going on.
Lordship, I have to take instruction.
Why? It's a whole matter.
Lordship, instruction is not received.
2018.
Lordship,
it
we
look
send
like?
our copy for instruction, but instruction not received. Lordship.
Huh?
Instruction we not received.
I heard Mr. A.R. Som, the learning council appearing on behalf of the petition. Your name?
K. Borpujari.
A. Borpujari.
K.
A. Borpujari appears on behalf of the respondent number 2. None appears on behalf of none appears for the Union of India, Assam University, as well as for respondent number 5. This court inquired with the learned counsel appearing on behalf of the respondent number 2 as to whether the project, namely molecular characterization of genetic diversity of N. fixing rhizobia, RHIZOBIA, of wild and cultivated legumes of Assam and Manipur is still subsisting, and also as to the duration of the said project. This court further inquired as to whether the Assam University has been given the grant for the DBT. That's major research project as above mentioned. The learning council for the UGC, Ms. A. Borpujari, 6 for an accommodation. This matter again on 31st May.
20.
Yes.
My lord, Commissioner before Lordship, my lord. He was junior assistant in Shohariya County, senior madrasa, my lord.
Yes, you have filed affidavit.
Already, my lord, respondent one has filed affidavit, my lord.
Secondary education.
Yes, my lord. My lord,
shall ensure filing of the affidavit by 1 P. They have filed in 2022. You have filed your reply?
No, my lord.
You are filing it?
My lord, in this affidavit, but they have admitted that the director of pension has raised an objection with regard to, my lord, that there is the provision for upgrade from the junior assistant to the senior assistant. In this regard, my lord, the Department of School Education Department has directed the Director of Secondary Education Assam to conduct a hearing by inviting all concerned and come into conclusion in the matter immediately. It has been reflected in para 7, my lord. So, my lord, so
there is some process going on.
going on. So, my lord, your lordship also dispose of, my lord. In
Why?
that
Keeping it alive would be beneficial for you. Something is going on. Something is going on.
para 7, my lord.
People where the director of pension has raised an objection on the matter, they say there is no provision for conversion application. And the matter
Secondary education, my lord.
it appears from the affidavit by Secretary to the Department of School Education that there is a proceeding going on before the Director of Secondary Education in respect to conversion of the upgradation of post of junior assistant to the senior assistant to the senior madrasa. This aspect of the matter is apparent from the paragraph number 7 of the affidavit filed on 28th of February. The learned counsel for the Secretary of Education Department will apprise this court on the next day as to what has happened in respect to the same hearing. This is the matter again on 7th of June.
Highly
21.
Yes.
What is this matter is about payment of arrears salaries and expenses.
My lord, these are the corporation matter. 21, 26, and 27, my lord. So my lord has fixed a series of matters on 29. There is a direction on the tribal affairs department, my lord, regarding that 17 crore.
17.19.
My lord. So my lord, so my lord, if my lord takes this matter also, because I have communicated the
item number.
item number, my lord, 21, 26, and 27 of today's list. My lord will take the matter with 5636 of 2016. That matter is fixed on 29.
These matters along with number
5636 of 2016. 16. 16, 16,
16 on
29.
29 of May.
$24.
Yes.
The matter relates to pension, my lord. The petitioner was initially appointed in 12 to 81, my lord, and works as field assistant, my lord. Thereafter, he was appointed as works as surveyor on 25/9/86. Thereafter, my lord, he was appointed in a sanctioned post, my lord, on 9/10/1990. As there was no break, my lord, he was granted pay protection. And thereafter, in 1919, he retired from service, my lord. 1919, my lord. 2019, my lord.
2019, you have.
Sorry. 2019, he retired. And now, my lord, he has been given only provisional pension, but not regular pension, only because that his period of workers period, my lord, that has not been regularized, my lord. That is why this pay protection was irregular, they say, my lord, the authorities, and he is not given regular pension, my lord. He has been given provisional pension at least.
So you were initially appointed as workers field assistant.
Yes, my lord. In 1986, my lord. 81.
So this continued.
This continued up to 86. 86, I was appointed as workers surveyor. So these two periods were under workers capacity, my lord. Thereafter, he was appointed in a substantive vacancy, my lord, in 9/10/90. Regular vacancy post, my lord.
Scientific assistant. So from you work for as a scientific assistant against the sanction post for almost
29 years, almost 29 years. Annexure Q or CMC, that will verify. The letter from chief engineer to deputy secretary.
In your case come within the ambit of solid forfeiture.
I have also filed an additional affidavit, my lord. In a similar matter, my lord, this authority has relaxed section 30, rule 31 of my lord, pension rules, my lord. Thereby, my lord, work search period was regularized in that case, my lord.
No, no, normally you get it. But the problem which I think is there with the authority concerned is that you were given some regular scale of it.
Yes. The pay protection has
Yes,
become.
what is the problem?
No, but they had PWD department, my lord, had moved the finance department. We have finance have already filed an affidavit here. Stating, my lord, that finance department does not deal with regularization of service in respect of workers' employees. Now the department was requested to take up the matter with personnel B department, as the matter of regularization of service is dealt with by personnel B department. And that decision of the finance department was communicated to the PWD department on 28/7/2021. To that extent, my lord, only we have filed an affidavit. And with regard to ex post facto approval for protection of pay, my lord, that has not been received by the finance department. Because the petitioner was initially appointed as, my lord, workers' field assistant. Then, my lord, he is seeking a pay protection, my lord, in the post of scientific assistant. Now, to that extent, my lord, the department concerned, line department, my lord, that is the PWD department, has to move the finance department with all particulars. That has not been received. That is what my affidavit says, my lord.
Personnel B department is also implicated here, my lord.
Yes.
But keeping him in the same post against the sanction post of scientific assistant. To be just what has been mentioned in polypurpose.
Polypurpose, yes, my lord, in a sanction post, my lord, he had worked. Now the catch will be whether the work is of perennial nature.
Perennial, obvious. Why will you otherwise have a sanction?
So that can only be said, my lord, by the line department, because
understood the line department. What
administrative because
My lord,
lordship will have to apply. If my lord applies,
but
if
why
my
you are
lord
having a
applies only
sanction
for
post?
my lord.
You are having a sanction post for scientific assistant.
Yes.
Meaning thereby that this post is of perennial nature. Otherwise, you would not have a post there.
No, the petitioner service, whether
the petitioner was there in the same post for 29 years. So he was there. So under such circumstances, and that too, it was the sanction post, against the sanction.
Yes.
If it is against the sanction post, that means the creation of that post was made as a perennial nature.
Government, yes, it is a regular employment.
It's a regular appointment.
Yes.
So that is why I say why Dolly Popular principles can't be talking.
Perhaps maybe my lord, but that affidavit has to come from the department, whether concerning the nature of the.
Why you are troubling with the talk? He wants to get away with it.
He's trying to pass the buck.
So if my lord is deciding the matter without any affidavit from the line department as to what was the nature, because the petition, my lord, amendments have been made by the petitioner, that has to be reversed.
No,
it is not reversed.
what was the nature can be, that is why I said, what was the nature can be very well incorporated from Dolly Popular.
Page 27, post is sanction.
Dolly Purposary is a dictum of this honorable court, my lord, no query. But if my lord applies Dolly Purposary to the section circumstances,
the Dolly Purposary says in one of the paragraphs, if I remember, that he was allowed to work, and that against the post which was there, and if this post is required, although it was on a contractual basis, but then also he will like pension because of.
But terms of employment, Dolly Purposary, it was contractual. But
then also it was given.
Yes, but the nature of work that she was performing, my lord, appears
Here
to
also it is for the scientific assistance.
no, they are deliverable, my lord, the affidavit were filed, my lord, exchanged, my lord, by the administrative department, secretariat, because he was working at the secretariat. Maybe, my lord, the nomenclature of her appointment, contract of service, my lord, it has been termed as contractual. Both said that he was working against the sanction post.
There was no sanction post for that.
Yes.
But that is post is required to review of this. It was kept all the thing, and she was appointed only on contractual.
Yes, she was appointed, but she was
Anyways,
performing. No, she
Mr.
was
Dhar,
performing those duties.
when are you filing your affidavit?
My lord, I will file, my lord.
When?
In next 2 weeks, my lord. 2 weeks, my lord. 2 weeks.
Upon heard Mr. S.K. Gupta, the learned counsel appearing on behalf of the Commissioner, Agopudari appears as a finance department, and Mr. Adhar appears for the PWD.
My lord.
He appears for PWD.
It appears from the records that the affidavit has position has already been filed by the finance department. However, the PWD department have not filed any affidavit. Adhar submits that he is going to file the affidavit without fail by 31st of May 2020. Taking into account the same, let the matter be listed again on 8th of June.
Like, my lord, I am appearing for respondent number
Who are you?
for accounting and finance. These are
Filing affidavit.
no, Lord.
Of like,
Oh, okay. You see, in that matter, I have not made anybody a party of that contempt matter. You'll get the order. Have you got a copy of the order? I will be given to you.
Okay.
I have not made because Samir Sinha is already there, so not necessary for taking steps against. I have not made 6 and 7 because Samir Sinha is the principal secretary, finance now. So he's already there. So why necessary? I have asked him to file an affidavit as to why the orders passed by this court has been reduced to a mockery.
Sure.
So you don't need to take steps.
And
That is
that
why.
affidavit you will have to file as a principal secretary of the finance department now.
No. As Samir Sinha.
No. Samir Sinha in the designation as principal secretary.
Obviously, I have asked Samir Sinha to do it. You see, the contempt proceedings is initiated against a person by name.
No, I understand.
So he has to do it being a accused, being an
Whether he is
alleged
in the
contempt now.
yes, in the health department or the finance department.
We are not concerned. I have mentioned it clearly why it is not necessary. Earlier, he was the principal secretary health. Now he is the principal secretary of finance. And as such, he is in know of the observation of Justice Surana also. But then also why he has reduced the order passed by this court to a mockery by giving 1,000 rupees.
All right. Fine.
I think, Mr. Gogoi, you should ask your clients to take appropriate steps.
Yes.
Because 69 lakhs is not a big amount for them. Not a big amount. Because it is really demeaning to an order passed by the court. And that too what they have done of giving 1,000 rupees is too little.
But also I was also.
It is really, if it was some other court, they would have initiated something. But
I will convey. All right.
I know 23.
It's study of justice covered by a trust department passing out 6/4/2021.
Yes, what is this matter about?
It is history of the old pension scheme is covered. They were appointed in 2001 and their service were regularized in 2000, received regular status of pay from 29 2007. It is covered here that is judgment. It is 31 3 passing 6403 and others.
Oh, that matter.
That matter.
This matter pertains to the old pension, new
Old
pension.
pension.
Old pension, new pension.
Last pension you have to start, but if it's
So you will be entitled to
old
old
pension.
pension scheme.
If shortest of 40, you are for the last of it. I have paid the quota.
You are all stipendiary teachers.
12 petitioner.
You have retired?
No, you're there.
Sharma, they are all stipendiary teachers.
Lordship, it appears lordship. 1800 per month.
First order to look like a stipendary teacher. Nature one. You were given a regular scale of pay.
Lordship from 2007. 29 2007. 209.
What is this order you have referred to?
The similarly situated person they have already granted my TPF and they have already page 93 already director
Islam Council the PM Sharma is on behalf of the
Paper number 1,
number
3,
1,
4, 5,
1, 3,
1, 3, 4, 5, 6,
5,
7, and 8. 6 and 7, Lord.
6 and 7.
Lordship. My friend is applying for 2.
So and so years on number 2. Why haven't you not made finance? Finance not required?
Finance is required.
Instant petition has been filed with the petitioner. Claiming that they are entitled to the pension in terms with the Assam Service Pension Rules 1969, as well as also entitled to subscribe to the GPF in terms with the General Provident Assam. What is that? General Provident, that is the amendment. General Provident Fund, bracket Assam Service Rules 1937, and entitled to subscribe to the GPF. The Learned Counsel appearing on behalf of the petitioner submit that the case of the petitioner is squarely covered by the judgment of this court. in the case of Purnima Hor versus State of Assam and others, reported in 2023 STC online GAU 1165, wherein this court at paragraph number 123 held that those teachers who come within the fold of stipendary teaching were entitled to the benefits under the Assam Service Rules, Assam Service Bracket Pension Rules 1969, and they are not covered under the NECPS, not covered under the new pension scheme in terms with the new defined contributory pension scheme 2009. This court further held that such teachers would also be entitled to subscribe to the GPF, which, apart from that, this court also held that such teachers would also be entitled to all other pensionary benefits to which a government servant of corresponding rank would be entitled to. The Learned Council further submitted that the petitioner had to appear from a perusal of the enclosures, annexure, perusal of annexure 1 would show that the petitioners were appointed on various dates as stipendary teachers. Thereupon, they completed the junior basic training and would appear from a perusal of annexure
Next 2, page
2
page 54.
CD,
Page 54.
and it was only on, when did you get?
2006. Yeah.
And it was only on, in the year 2006, they were given the regular scale of pay.
It was from 29 2007.
2007.
2007.
Regular scale pay from 2007.
They
2009.
were only given the regular scale of pay from 2007 on. Further to that, the Learned Council had also submitted that initially there was a deposit, initially the petitioner deposited and the petitioners had subscribed to the GPF, but subsequently, in pursuance to an order issued by the Director of Finance Budget Department to the Deputy Accountant General PA, dated 23/2/2010, the petitioners were not allowed to subscribe to the GPA. It is under such circumstances, the petitioners have therefore approached this court, claiming the reliefs as sought for. Upon perusal of the materials and hearing the Learned Council appearing on behalf of the party, this court is of the opinion that the case of the petitioner is fairly covered by the judgment of this court in the case of Purnima Hor Supra. Accordingly, the petitioner's hearing would be entitled to the benefits under the rules of 1969 And the petitioners are not covered under the NDCPS 2009. This court further observes that petitioners would be entitled to subscribe to the GPF in terms with the General Provident Fund Assam Service Rules 1937. Taking into account the same, taking into account the above declaration, this court therefore disposes of the instant petition, thereby directing the respondent authority to do the needful, so that the petitioner are granted the benefits in terms with the rules of benefits of pension in terms with the rules of 1969, as well as the GPF in terms with the General Provident Fund Assam Service Rule 1937. This court further makes it clear that in doing so, the state authority would be at liberty to deduct such amounts which were deposited on account of in terms with the NDCPS 2000. Yes.
Kindly peruse the court order 35.
Yes, Mr. Shraga.
The proposal has been sent to the government by the Director of Elementary Education Department Law.
What have you done in terms with the order passed on?
It was sent on 2nd May.
Because this court fixes the matter on 12/5 to the on which day Mr. P.N. Sharma, the learned counsel, shall apprise this court at what is the status in pursuant to direction passed by this court. The order dated 12/2/2016. What have you done?
Lordship, there were certain deficiencies in the earlier proposal, and again, after meeting of those deficiencies, Lordship, the Director of Elementary Education has sent the proposal for approval to the government.
Mr. Khan, you're Mr. Khan. Who are you? Huh? Ekedas. Yes. Now tell me, how many repetitions you have filed? What is this repetition for? Now the government has not given any instructions. When did you send this?
Lordship, it was on second of May, Lordship. It appears.
As well as other people who are received the connection, but no government instructions have been received so far by the other side. And you send it to whom?
To the secretary, Lordship.
Secretary of what?
Education.
Secretary. Who appears for them?
I appear for
them. So this is the tussle between you and you. Oh, yes.
No, Lordship. Once the
You are blaming yourself. You are saying that you are the director of elementary education. You are appearing. You are also appearing for the secretary to the government of higher education. Now they have not done. Now tell me why the government has not done anything, even although the communication was mentioned out there on 28th of December 2022. Why does it take 5 months for the government to take any action?
They should have sent it to the PNPT department, Public and Pension Department.
Who?
That education department for that controlling.
But they are sending to the secretary.
They are in a own department there.
Let me appear. Otherwise, today only I have received this instruction, Lordship. So I will have a concrete instruction, Lordship. Lordship, fix next week.
No, this amounts to a violation. So you have woken up after 6 years. So we will hold the responsible officer to be the director of elementary education. Because on the last occasion, I have asked you to find out who is the person concerned.
Lordship.
So the director of elementary education is the person concerned, 28th of December. So if it has taken for compliance of an order passed by this court 6 years, so this 6 years interest has to be borne by from the pay of the director of elementary.
Lordship, fix next week, Lordship. I will.
No,
I will
nothing
have
doing. This is what you are doing.
Lordship.
Why have you sent it on to the secretary to government of Assam? Now who is no. The condoning will be done by the secretary to the government of Assam only.
Lordship.
It can't be done by the director. No,
not director. Lordship, by the Pension and Public Grievance Department, the government.
So they had to send it there.
Yes.
Not to the secretary to the government of Assam.
Perhaps through the secretary, Lordship.
And the secretary has not sent it.
That reminder has been sent, Lordship. Lordship will fix the matter next week. I will obtain concrete instruction.
But Mr. appearing on behalf of the PN Sharma appears on behalf of the standing council for the respondent 1, 2, and 5. Mr. S.R. Bosa appears for the respondent number 3. Mr. P. Who appears for respondent number 4. This court, by the order dated 3/5/2023, sought for the instruction from the elementary education department, elementary,
Lordship,
as to what is the status pursuant to the directions passed by this court in the order dated 2/12/2016 in WPC number 4376 of 2016. Today, Mr. P.N. Sharma, the learned counsel, have produced a set of instructions issued by the Director of Elementary Education. It appears that in pursuance to the order passed by this court on 2/12/2016, on 28/12/2022, the Director of Elementary Education have written to the Secretary to the Government of Assam Department of School Education. However, it seems nothing has been done in as much as a similar communication was issued on 2nd of May 2023, again to the Secretary to the Government of Assam Department of School Education. Mr. S.R. Borwa, the Learned Counsel, appearing on behalf of the Director of Pensions, submitted that this proposal has to be further submitted to the Pension and Public Grievance Department of the Government of Assam. In as much as without the same being done, the order dated, the directions in the order dated 2/12/2016 in WPC number 4376/2016 cannot be complied with. However, from the perusal of the documents which produced, it does not seem, it is not seen that the respondent authority, that is, the Secretary to the Government of Assam Department of School Education, as well as the Director of Elementary Education, is aware of about the gravity of the directions passed by this court on 2/12/2016 in WPC number 4376 of the 2016. Be that as it may, Mr. P. N. Sharma, the Learned Counsel, appearing on behalf of the respondent number 1, 2, and 5, request for an accommodation so that further instructions can be taken from the Director, from the Secretary to the Government of Assam Department of School Education as to what steps have been taken pursuant to the communication dated 28/12/2022 and 2/5/2023. This is the matter 15.
Lordship. Today, 15 Monday, Lordship. Lordship will allow
Next week.
next week, Friday, Lordship.
This is the matter again on 24th of May 2023. This court further puts the respondent numbers 1, 2, and 5 to notice as to why interest could not be imposed upon them for the delay in finalizing the pension proposal of the petitioner.
Apply.
33.
The matter relates to non-payment of arrears salary to the petitioner from the period of 1/1/2013 to 29/2016. The last occasion, 24th of March, he has also directed the spending council to apprise the court as to whether the arrears salary has been disbursed or not. But my instruction is, it has not been disbursed till today.
Lordship, here also I prefer some accommodation, Lordship, where instruction is awarded, Lordship.
I gave you 2 months.
Lordship.
Then
they are verifying and that the instruction is still awaited, Lordship. Lordship,
means they are not interested. That too, why interest did not be imposed upon the elementary education for delay. So now you accept that
order has already been communicated, Lord.
Then
they are verifying.
Then also they are not.
That instruction is still awaited. They are verifying, Lordship. Personally, on the same date, Lordship, on 24th, I will have the instruction.
But Mr. Chetty.
MR Adhikari. MR Adhikari.
Or Mr. MR Adhikari on behalf of the petition. And my appeal for the elementary education. The instructions so sought for on 1/3/2023 and 24/3/2023 is still awaited from the elementary education department. elementary education department into notice as to why interest should not be imposed on the elementary education department for the delay caused in payment of the arrears salary of the petition. Be that as it may, the even after a passage of more than 1.5 months, there is no instructions available. Be that as it may, this court fixes the matter again on 24th of May, on which state, if no instructions are made available, this court shall pass appropriate order.
I have a small prayer regarding date. On 23rd, when I'll be out of Sambala in connection to my sister's renal transplant. So can it be on 29th of May?
You'll be happy. Yes.
Right.
35. Yes, Mr. Abhijit. I can copy the receipt of the paper. Yes, it has been sent by respondent number 8. Who is respondent number 8? Oh, some college.
Yes, the principal of Krishna Higher Secondary.
But he has not appeared.
He has not appeared.
In fact,
have you served the notice?
Yes, yes.
You have served a copy of this order?
Yes, my lord. In fact, justice service is also given.
Have you served a copy of this order? The last order. I hope you have read that order. You are appearing for me, sir.
I am for respondent number 7. My principal solution is this.
Who is this? No one is appearing for 8. So the direction was given to respondent number 8. Where is it? Have you served the copy?
I have served the last order. I have served the first order.
Mr. Everything. This order was passed in your presence. You don't care to look into it. Then, I made it clear the respondent number 8 is directed to forthwith upon receipt of a certified copy of this order, which the petitioner is directed to serve to the respondent number 8, shall send the proposal of pension entitlement of the petitioner's husband, as well as the family pension of the petitioner, to the respondent number 5.
Sorry, ma'am. My lord, we have sent it through the registered court. It's the
Fantastic. This is the matter of the as the petitioner could not show any document to show that the order dated.
My lord, would your lordship be pleased to only give one?
When 31/3/2023 have been served upon the respondent.
My lord, if your lordship is pleased,
8 weeks.
No, I may be allowed to give
10 weeks.
I may be allowed to give
10 weeks. 10 weeks.
No, I'm not saying about the time.
12 weeks. I'm not concerned. You are supposed to do it. With the order passed. This court has given special importance to that matter, and you have given this orders. If the petitioner is not interested out there, why should this court take up this matter urgently? Have you not seen this matter has been taken out of turn amongst the others, and you have not complied with that? And what is this registered post business? Why this particular order couldn't be served? Then the only things will move. It is because of the respondent number 8 not appearing before this court. This court has passed this order. Then I could have passed appropriate order for compliance. I can't do it now. Once you serve that order, then this court can take up any contempt proceedings or initially if he doesn't do it. But we have not done it. Why should this court care about this?
I'm extremely sorry.
6 weeks.
36.
Would your lordship be pleased to make it after 2 weeks? I'll do it within 3 days.
listed after it.
Obliged.
May I please? In this case, I have received instruction, my lord. And as per, I don't know 36. As per my instruction, my lord, the petitioner schools are amalgamated to high school, my lord. So the director directed to DEO to submit test proposal before the secondary director, secondary education department.
So this is the direction be given to the district elementary education.
My lord.
For providing certain information. And how many petitions have been filed, Mr. Tina?
This is the second round of petition, Your Lordship.
Second?
Yes, Your Lordship.
You have filed 539. What is 541?
Your Lordship, that was filed way back in 2014 with a prayer to clear my area due. So this honorable court passed the direction that you examine their cases, and if they're eligible, you release that. Thereafter, in persons to that, in fact, the supernumerary post was also created for payment of the salaries. And 7 persons who were along with us had received it, but we were denied it. In fact, the commissioner and secretary has passed an order to that effect.
All these verification business. You have passed, the director of elementary education have already passed an order on 23/3/2018. Then the secretary to the government of Assam elementary education department has also passed an on 18/6/2018.
Yes, sir.
Finding out the entitlement. What is this verification again?
Subsequently, my lord, amalgamated to.
So what? These are orders out there.
Now the proposal submitted before the.
I am not concerned with all these things. You are bringing those district elementary education, we are not concerned. When the entitlement has already been fructified out there in 2018, does it take another 5 years for doing it? Or amalgamation, you do whatever you like. But how can you keep on delaying the rights of the petitioner to get his area salary?
Now, my lord,
I'm not concerned with now all these things. These documents have doesn't show anything to them.
Your Lordship has passed the order on 3/4/2023, and this letter was issued only yesterday, 11 May 2023.
No, is this on the basis of the incremental benefit?
No.
Every time whatever keeps on happening, this has already been decided. Then,
so Lordship may Lordship may dispose of director to.
So that he again comes again.
Yeah.
So that again after 2 years he again has to come.
Oh my lord,
So filing another.
this time, my lord, they are. This time they are supposed.
I will dispose of with the direction to pay this amount along with cost of 18% to be paid from the salary and deducted from the salary of the director of elementary. You want that? Mr.
May it please, your lordship, may I make a submission, your lordship? I'm lordship may dispose it off, but again I have to come back as your lordship has rightly observed. So your lordship may direct them to clear the dues within a period of 1 month, or your lordship can take a suo motu contempt proceeding in that case, your lordship.
That I'm not going. I'm asking them to, directing them to pay.
Yes, sir.
Within 1 month, along with interest, with deducted from the salary of the director of living. But Mr. R. Sinha, that I may absolutely have petition. Mr. Peter, that appears to have only
Elementary education
one,
matter for 1,
2,
2,
and
and
3.
3.
It's
Okay, the second.
also appears to respondent number 4. The case of the petition is here is that the petitioners are entitled to certain area salary. For the period from
28/2010 to 3/5/2012.
8/2010
to 3/5/2012.
3/5/2012. As the said salary, area salary was not paid, the petitioner had moved this, had filed a petition. Before this court, which was registered and numbered as WPC number 541 of the 2014. This court, by an order dated 22/5/2014, disposed of the said petition. Thereby directing the Commissioner and Secretary to the Government of Assam in the Venture Department to look into the grievance of the petitioner by calling for a report, etc., from the appropriate authority, including the respondent number 4 therein. It was further observed that in the event it is found that the petitioners are entitled to receive salary for the aforesaid period, the same may be disbursed. It was further directed that the said exercise be completed within a period of 3 months from the date of furnishing of a certified copy of this order, of the order dated 22/5/2014, along with a copy of the writ petition and its enclosures. Subsequent thereto, it appears that the Director of Elementary Education had in its order dated 23/3/2018 observe the past and all. Observe requested the government to take necessary action for regularization of the gap period by creating supernumerary posts of assistant teachers of upper primary schools out of the balanced budget provision under the heads of accounts, and to accord sanction for payment of the area salary to the petitioner as per the government letter dated 21/10/2011. The petitioner's name duly appear. All the petitioner's names duly appear in the order dated 23/3/2018.
Yes, sir. One more thing, Your Lordship, just made a statement that from 28/2010 to 25/2012, in the column, the gap period has been mentioned. It's different for all the petitioners, sir.
Then why have you filed all different one petition with every?
Because their cause of action was same and they're appointed in terms of same process, Your Lordship. 1-2 months here and there, Your Lordship, because they have completed their basic
You have
training.
not even paid the court fee.
I'll pay it. Actually, it was the
Mr. Archina, the learning counsel, you tell the appeal, you have to tell me it is part of the instructions for the order dated 3/4/2023, as well as the order dated 3/2/2023 and 3/4/2023 has not been till date. The learning counsel for the elementary education department 6 for an accommodation. Time is granted till 31st of May 2002. It further appears that there are 12 petitioners in the 13 petitioners. However, the court fee of only one person has been one petitioner has been paid. Although the entitlement of each of the petitioners are separate and distinct, considering the above. The learned counsel for the petitioner subjects that he take appropriate steps for meeting the petition. 37.
Also, on the last one, I placed an instruction where the director of elementary education had communicated to the
The
DO.
death of the husband of the petitioner, the state tribunal has been closed as awaited. Orders were submitted by the learned petitioner that the steps are being taken for the purpose of assessing actual entitlement of the for which 2 weeks time is taken. So I fixed it after 1 month. What happened?
Also, once this proposal is received by the director, that proposal is yet to be received from the DO, Lordship. That after correction, Lordship, certain calculations were wrong. So after rectification of all these mistakes, Lordship, that fresh proposal was supposed to be sent by the DO. Once that proposal is received, the director will process it and send it for proper sanction. Lordship, we have fixed after 1 week, by after 1 month, Lordship. By the time, perhaps.
No, I have already given you 1 month.
2 weeks, Lordship.
No. We'll have it on 17th.
Lordship.
It's the matter again on 17/5/2023. On which date the learned counsel for the elementary education department shall obtain the instructions in terms with the order dated 10/3/2023 and 3/4/2023. 38.
Yeah, we are not.
Yes, where is the PNRD?
What if there's a direction to the finance department?
Yes, finance department. No finance.
When we have finance giveaways on legs, can we take up sometime if possible?
He is claiming the benefit under offender. Minimum of the scale of pay.
And the department has already sent the lordship in the order itself. Lordship has mentioned. The serial number is 100.
Yes, Mr. Gogoi.
But here, we have already communicated with the PNRD department now, seeking certain information, but nothing has come up. So that we can examine whether the petitioner will be entitled or not.
When?
It is of my lord 24th of March. I can provide a copy to her. Otherwise, my lord, the procedure is, my lord, they should have moved us, my lord, along with the proposal.
They say that they say where the petition name was found that this type of the so very it has been mentioned that the date of occasion for the petition to be transferred and the length of service is taking into account the standard of contracted to finance it. So they have not moved the proposal to you.
But as per this letter, my lord, we have now, my lord, asked them, my lord, to furnish the documents to us so that we can examine them. Let us, my lord, Lord, may give me at least few more days, my lord. We'll give a reminder to them. Then I will.
No, they are there.
They are otherwise there.
Then why should we?
I will furnish a copy to her.
You give the copy to me. I'll put it on record.
My lord.
And then I think they will pick up.
Lordship, on the last day, Lordship, proposal was sent and it is in the record, Lordship, as X. And the petitioner's name was at the page, Lordship, 110 serial.
So they will
It was
examine
sent
it
to
for the
the
reference.
Finance Department for only for approval. Lord.
Yes. It is given.
Yes, sir.
Then
it was sent
to the Commissioner of Finance.
Lord.
The submission was given on 17th of March or November 2021.
For approval. And it is also
Directed
mentioned
to
in order.
include herewith a copy of the letter and the reference received from along with the order of you request to submit the detailed report. They have already submitted the
that communication, my lord, if I can have a copy, my lord, immediately I can have the
that is a part of Annexure X. They only gave it to me on the last occasion, madam. Madam, you are Nivedita Bora. Yes, this document was directed to given to Ms. Nivedita Bora. And thereafter, that was closed out there, the 17/11/2011, wherein the petitioner's name is there in this number 5 at the serial number 108.
110, Lord.
Huh?
110, Lord.
110. The petitioner's name was there. Why haven't you paid him the? That is the only question. So the proposal was duly submitted.
Madam, let me have a photocopy of this. Madam. I will have an instruction by Friday next. At least.
Huh?
By Friday next, I can have the instruction.
Have it, because this instruction which we have given is prior to my order.
But my lord, the proposal is of my lord 17th of November 2021.
Understood, but the instructions which we are giving is prior to my order. What have you done in pursuance to this order? Because this communication is of 24/3/2023. My order is of 27/3/2020.
Well, let it be on Friday then. I will have a photocopy of this one.
Amen.
Yes.
Yeah.
And it's a big way. The instruction which was called for by the order dated 27/2060 from Finance Department. Not forthcoming. And the Learning Council appearing on behalf of the Finance Department 6 for an accommodation. This is the matter again on 19 May 2023, on which date the learned counsel shall obtain the necessary instruction in terms with the order dated 27 May 2023.
But on that day, Lordship, I may be allowed to mention for agreement.
Petitioner is
39.
At your lordship, matter pertains to non-payment of arrears salary. Lordship, kindly peruse the order dated 31/3.
yes. What instruction?
Lordship, here also, the DO is yet to submit.
No, I don't understand. The person has retired in 2021.
Lordship.
But why is it taking so much of time? Have you given the provision? Are you getting provisional?
Lordship, we have received the subsistence allowance. There is the due of rupees 8,70,000.
8,70,000, you have got it.
No, Lordship, this is the due. Has not been paid to the.
How much you have got? Now you are still in service.
No, Lordship, I have been retired on 31/12/21.
Okay. Now what is happening? You are entitled to what? Are you getting your pension?
No, Lordship.
Huh?
This is perhaps for the area salary.
This is for only for area salary.
Yes, Lordship, this is only for arrears salary.
Then, so you're getting your pension, huh?
This is only for the area salary.
The instructions of support. Ms. S. N. Gupta, the learned counsel for the appears on behalf of the elementary education department. The instructions of support by orders dated 15/3/2023 and 31/3/2023 still awaited. This is the matter again on 31/5/2023. On which date, if the counsel appearing on behalf of the elementary education department cannot provide the instructions at court, this court shall be constrained to pass appropriate orders in the instant repetition.
This case got on the earlier occasion.
File affidavit.
Well, they are taking further 4 weeks time to file the affidavit. I got a letter. 11th of May.
MP Sharma, the learned counsel for the petitioner,
I pay for the finance department, respondent number 2.
Mr. appears on behalf of the respondent number 2.
For respondent number 4.
Appears for the respondent number 4. A PNRD? Who is paying for 1 and 3 is what? It's PNRD. What is respondent number 1 and 3, Mr. Sharma?
It's PNRD.
PNRD. Where's PNRD? Okay, none appears on behalf of the Panchayat and Rural Development Department. This court, by the detailed order dated 22/3/2023, directed the respondent authorities to file their affidavit by 4th of May 2023. However, no such affidavit has been filed. The learned counsel appearing on behalf of the Only you want, huh?
Yes, my lord. Regarding my lord, fixation of pay. So
Appearing on behalf of the finance department.
My-
6 for an accommodation of
4 weeks, my lord. Let it be
4 weeks.
The
for
meantime,
filing.
we'll file it.
So 1 week is 2,000. 4 weeks is 8,000.
To file the, but it's regarding fixation of pay, others they are getting their salary.
No, but not filing that.
It's 2023 matter, my lord.
Understood. But he is waiting. It is on a fixation of pay.
Yes,
And what
sir.
happened as regards the representation?
Lord,
There is a representation which was submitted to the finance department.
in that case, Lordship may dispose it of my lord,
No.
within a time frame. That's why I'm saying we will file.
That can't be done because of the fact that what they are asking for is not that. I still give you the liberty. See,
But-
the state representation as per the bill is still pending. In the meantime, on 2nd of July, had issued a communication to the senior account officer of Cohen, thereby informing that the fixation of pay of Cohen, the procedure shown in Cohen may be followed. The said communication has been put to challenge by the petitioners before. It is further apparent the petitioner has submitted a representation on demand to the principal secretary with a prayer not to apply case 1A of appendix and table number 12. However, the petitioners were drawing the salary of payment going to a great rate. These, as per the learned counsel, is still pending before. Taking into account the above and stand taken in the return, the respondent shall by so file the affidavit as regards the challenge made by the petitioner and the claim of the petitioner, and also state as to whether the petitioners are entitled to the claim as made in the taking into account that the petitioners are retired employees, an attempt shall be made to dispose of the writ petition on the returnable date.
Well, in that case, 2 weeks, man. After 2 weeks. The last one, Lordship may indicate, man. Retired employee. Cost may not be, my lord. Part
No,
they
no.
filed, my lord. At least 2 months they can wait, my lord. At least.
No, it is not
All
the
this-
question of 2 months.
Because the ROP was of 2017, man. They have approached in 2023.
Seek for an accommodation of 2 weeks to file the affidavit. Madam, you are appearing for PNRD? Are you filing affidavit? No. Filing? Counsel appearing on behalf of the PNRD as well as the finance seeks for an accommodation of 3 weeks for filing the affidavit. This is the matter again on 14th of June 2023. The affidavits may be directly filed by 7th of June 2020. It is made clear if no affidavits are filed, this court within the same time, this court would be and further time is requested. This court would be constrained to impose cost upon the statement.
Well,
voluntary retirement after 23 years of service. And same was granted only after intervention of High Court, Honorable High Court. But she is yet to get her pension.
Yes.
Lordship, pursuant to the order dated 4/4/2023, Lordship of this Honorable Court, the director on 28th of April 2023 communicated to the DIF school to submit the report. Lordship. Otherwise, that proposal will go directly from the DIF school to the director of finance, Lordship. So that communication is there, Lordship. So that instruction, concrete instruction.
Will go to the AG office or the director of
Director of finance.
In case of LP school,
It will come to the director of pension. We are yet to receive the proposal.
after receipt of the proposal, then again you are going to send it back on the ground that what about the delay in so many years? That has to be again condoned. Isn't it? You have some rules, no? 207 and 208.
Yes.
Then person is without pension from 2016. 7 years have gone by.
Lord.
Then why is it still in the state of? I would have understood that you have already taken steps. Nothing has
Lordship,
been
perhaps,
done.
Lordship. Otherwise, that perhaps the DIF fiscal might have already sent, but that report is not there, Lordship. So therefore, the director has already on 20th of April by this communication, Lordship. You should report. Your report should reach this office on or before 3rd May 2023 positively for onward submission.
But then also nothing has happened.
But failing which you will be held personally responsible. That is also there.
Then
thereafter also that instruction is still awaited. Lordship from the day.
We'll have it again on 22nd.
Lordship.
Get any updated instructions. Or Mr. B.K. Bhagwati, the legal counsel, for appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the respondent number 1, 3, 4, and 5. Mr. B. Gogoi appears on behalf of the respondent number 7. Mr. B. Chakraborty appears on behalf of the respondent number 2. And Mr. S.R. Gurua appears for respondent number 6. This court, taking into account that the petitioner have not received any pension since 1/6/2015, had asked the respondents to obtain instruction as to apprise this court as to why the petitioner has not been paid his pension as well as his pensionary benefits. Mr. P.N. Sharma, the learned counsel, appearing on behalf of the respondent number 1, 3, 4, and 5, submits that the Director of
Elementary Education Department
Director of Elementary Education have written to the Deputy Inspector of Schools, Guwahati, on 28 April 28/4/2023, as to submit a report by 3rd of May 2023 as regards why the pension of the petitioner have not been paid. However, no instructions have been received from the respondents in the Elementary Education Department pursuant thereto. Let this matter be listed again on 22nd of May 2023, on which date Mr. P.N. Sharma, the learned counsel, shall apprise this court about further developments in the matter. Mr. S.R. Bolwa shall also apprise this court as to whether any pension proposal have been submitted by the Elementary Education Department so far as the petition is. 42. Liberty is given to the petitioner to mention the matter for.
Lordship, here in this matter, Lordship, before my senior counsel starts, Lordship, I am praying for an accommodation of 10 days, Lordship. I am here to receive the written instruction, Lordship.
This is regarding order of suspension.
4120.
The instruction was asked for on a very limited scope.
Yes, Lord.
As to whether you have served the memorandum of charge.
Yes, Lordship.
Have you done?
Lordship, I have received certain telephonic instruction, but I have not received written instruction, Lordship. So, Lordship,
But the person you are keeping, there is a right which accrues upon him if you don't serve the memorandum of charge.
Yes, Lord.
He was suspended on
4123.
4/1/20.
4th of January. 4th of January 23.
4th of January 2023. Until now, if you have not done, you should have done it by 4/4.
Yes, sir.
As per audio charge, if you have not done it, that is to be reinstated. Then
Let me have the written instruction, Lordship, after 10 days, Lordship. 10 days, Lordship.
15.
Of like
Monday.
Yes. Lordship, tomorrow is a holiday, Lordship. Can it be on 17th, Lordship? 17th.
Let me stay and pick up the next meeting. Yes, on behalf of the higher education. You women submitted the instructions to talk for in the order dated 26/2023. matter where it directly proves upon the petition on completion of the period of 90 days from the date of suspension to be reinstated if no memorandum of charge of charge sheet has been served upon the petition. This court fixes the matter again on 17/5/2023, on which date the learned standing counsel for the respondent of one and two shall obtain the instructions in the matter. Liberty is given to the petitioner.
Liberty to upgrade.
43.
Yeah, please. As per the time, my lord, imperial order already state, my lord.
Wait. It's something they have got for me. This doesn't happen. Why is it? Lose with the battery must be. Yes.
Yeah, lord. As per the time, my lord, imperial order already state, my lord. Government side acts to obtain instruction.
Yes. Have you got the instructions?
Lordship, inspection.
No.
Not that part. Whereas my lord had friend, my friend
You
served the
are.
extra
You have got
copy.
an interim, na? Status quo is there.
Extra copy served on yesterday itself. I have received.
And I'm not sure whether the elementary department has received the extra copy.
You have served the extra copy yesterday?
Yes.
Huh? Why?
That was forgotten. I'm sorry, but I text him.
Yes. Then I also should forget to extend the interim order. I will forget now to extend, as you have failed to submit this here on time. Mr. R. Islam, the learned counsel appearing on behalf of the petitioner, and Mr. P. N. Sharma appears to respond for 1, 2, 4, and 5.
1, 2, 3, 4.
Three, no, three he appears.
I'm for
Mr. S.R.
1,
Bulba
3,
appears
4,
to respond to the This court, by an order dated 3/5/2023, have sought for the instructions from the respondent elementary education department as to the reasons behind the order dated 26/4/2023. However, the said instructions have not been received. Accordingly, let the matter be listed on when
Up to the period.
on 5th of June 2023.
Earlier, please.
47.
Interim order passed the
Recovery due to wrong fixation of pay, lordship. There is a order, lordship, passed by this honorable court in WPC 719 of 23, dated 7/4/23. It can be disposed of.
Where?
in Jogaro City Estate,
Got a similar order somewhere. You
Yes,
got that
Your
order?
Lordship, that same matter, the Lordship remembers the similar matter.
Where is that order?
My Lord, that has not been annexed because.
You
that-
have a copy of it or not? You appeared on the last occasion in that matter.
Yes, Your
Remember? Then you have to wait.
I'll furnish
Don't
it,
get
Your
it.
Lordship. I'll furnish it today. I'll furnish the order today.
And help it. Then the court keep on waiting for it. Have it on some other day. Or Mr. S.K., the learned counsel appearing on behalf of the appears on behalf of the phone number 1 and 5.
1, 5, and 6.
Mr. 1 and 5, Mr. B. Chakraborty appears for respondent 2 and 3, and Mr. B. Gogoi appears for respondent number 4. Who appears for Devati College?
Notice.
None appears for respondent number 6. Is the service complete?
Yes, your lordship, it was deemed to be served.
How?
Registered post the track delivery report said that it has been done.
Have you
Delivery has
taken
been
the
done.
service?
Lordship,
You have not taken the service. It appears from the office note dated order of the Lozima Court dated 3/5/2023 that the service upon the respondent number 6 have been deemed to be complete. Taking into account the same, let the matter be again listed on 29th of May.
much obliged.
48.
May I please, your lordship? Your lordship, my senior is in court number 4. So the matter may be taken after some time.
I have received my instruction. I'll file my affidavit at the same time. My lordship, I asked for a record. I have received a record, but records are not the actual record. My lordship, there are some papers without any note sheet. He's enjoying a stay order.
Behind the issuance of the order dated 8/2 as well as also produce the records pertaining to the orders taking into account the allegations of matter. Have you filed the affidavit?
No, I'll file my affidavit. I have received my instruction.
Huh?
I have received my instruction, but the record has not been furnished to me. But record I have received it, but it's a different record without any note sheet. That's why there is some time to get the actual record.
Mr.
You host.
You host the learned counsel for the petitioner. Who appears for respond number 1? What is respond number 1? Secondary education. Mr. P. N. Sharma appears for the respond number 1. Sir, you are? Who appears for the PTC or you? Mr. S4 appears for respond number 2 and 3. What about respond number 4 and 5?
4 and 5, there is a Lozima order, my lord. Service is complete.
As regards the respondent number 4 and 5, it is been seen that from the order dated 5/2023 of the Lozima Court that the service has been complete. Considering the above, however, none has appeared on behalf of the respondent number 4. Be that as it may, the learning council appearing on behalf of the respondent number 2 and 3 submits 6 for an accommodation for filing the affidavit as directed by the order dated 27/2023 and also to produce the records pertaining to the orders dated 16/2023 and 14/2023.
First order date 8/2023.
14/2023 and 16/2023. Is the matter well?
After 2 weeks, lord.
Don't, you can't get it, don't tell me. Because otherwise this is already enjoying a hearing. So we will have it well. On 12th of June.
Lord.
Is the matter again on 12th of June 2023. In the meantime, the interim order passed on 27/2023 stands extended till the next.
Item 25.
Lordship, the matter has already been moved to the government, Lordship. I need 3 weeks time to obtain the instruction.
Mr. S. System, the learned counsel for the petition. You Yes, on behalf of the health department. You are still serving,
Presently
but
holding
you
the
have not got the salary from 1/6/2011.
due to fault of the government.
Lordship, currently he is getting the salary, Lordship, from 1/2/2016 till date, Lordship, as senior, as sub-divisional medical and health officer.
Is getting salary. It has been submitted on behalf of the health department, also for the health department, that the petitioner have been receiving the salary
from 1/2/2016.
1/2/2016 till date.
Yes, Lordship, as senior, sub-divisional medical and health officer.
As senior,
as sub-divisional,
as subdivisional
medical and health officer.
Senior,
No, Lord.
as subdivisional medical
and health officer.
But his post is senior medical and health officer.
In his earlier senior medical officer, presently holding the post of sub-divisional medical health officer
As subdivisional medical and health officer at
Lahore.
At Sabua.
Lahore.
At which hospital?
Lahore PHC. Lahore PHC.
At Lahore PHC. The council for the petitioner directed to apprise this court on the next occasion as to whether the petitioner have got the salary for the period of application. However, it is the case of the petitioner that the petitioner have not received the salary from 1/6/2011. The learned counsel for the respondent shall apprise this court as regards why the petitioner have not received the area salary from 1/6/2011 to 2016.
Yes.
To 31/1/2016.
They filed the affidavit, the HP Dibrugarh filed the affidavit because there is no post, so the adjustment could not be done. So that has already been included in our affidavit.
Yes, to whom appears on behalf of respondent number 7. And you are appearing for?
For 80 Lordship, respondent number 4.
Also appears for PD and Mr. P. Gogo appears. Okay, yes, well.
After 4 weeks.
11 on 14 June.
Oblige.
28.
Yes, elementary. You wanted to file an affidavit?
28, Lordship.
You file an affidavit?
We will file our affidavit, Lordship. The petitioners here are the illegal teachers, Lord.
Fantastic. But why are you saying them to be illegal?
Lordship.
Have they got any salary?
Perhaps they have.
2012,
No. Did you get any salary at any point of time?
Yes, sir. Before 2012, I did.
Okay. Now, did you participate in that screening committee?
Yes, sir.
Now, what happened in the screening committee?
In the year 2014, Lordship, they asked to appear before the verification authority. Accordingly, I have appeared. Thereafter, I don't know what happened.
Huh?
Thereafter, Lordship, no communication.
Now, so, and you are still working?
I am still in service.
You put these things on affidavit. I will file an affidavit. To the fact that you participated in the screening committee, you are still in working, and from when you did not get the salary. You must have mentioned that, but the other two aspects, so that is very relevant. Because now what the government has done, that those people who have got the salary in 2007 and had the qualification, they were, and that you participated in that screening committee, you mentioned, okay? You file your affidavit. Hey, Aditya, hello. Order.
It was item number
13.
15.
15.
Item number 15, Lord.
On 26.5, you do the needful and you file your affidavit.
Lord, will file our
Or because that affidavit may also help you out, because that would be your step. But only thing is,
only thing, Lord.
as to whether the petitioner participated in the screening committee.
Lord. Only this.
You bring that aspect, huh? Because that is the relevant. Because on that day, I will take up a decision on that matter, which will help you. And you have passed the junior basic training.
Yes, Lord.
So that is there. So you bring it by way of it. At least the matter along with it.
6722 of 2015.
On 6722 of 2015. On 26th. You file your affidavit, not mentioning all these things. So the otherwise you can see that the court is advising.
29.
Yes, please, your lord. There could be responsible by an affidavit.
What matter is this?
My lord, the matter pertains to primarily the petitioner. He is working as an assistant in the Tezpur University, and he is claiming that he is eligible for promotion, your lord.
So to promote the petitioner to the post of section officer. Hear me?
Yes,
Fantastic. Now, what do you want?
My lord, my primary prayer is that I may be promoted to the post of section officer. Because I've served for more than 10 years as a junior accountant, your lord.
Who is appearing for the other side?
Well, I'm for the respondent, UGC, Lord.
UGC, you are not going to promote.
Yes,
Promoting
yes,
is run
my-
by the Tezpur University. Who is he? Nobody appears for the Tezpur. Has the service been done?
Service was well, generally, Senior Counsel Mr. Ansidas appears.
Oh, Mr. R.K. Dev Chaudhary appears for respondent number 1 to 5. So he is no longer here. All the respondents.
So 6 is.
And for whom are you appearing? For 6, when did 6? Oh, 6 is there. You are appearing for 6.
6.
None appears for here. Neither affidavit has been filed. Now, what is he entitled to his promotion?
That can be examined by the Tezpur University. So there it is.
The Tezpur University is not before this court. Okay. Heard Mr. S. Day, the learned counsel for the petitioner. Mr. A. Samoa appears for the respondent number 6. None appears on behalf of the Tezpur University on call. You want to file? Are you filing
My
affidavit?
lord,
No.
I'll take instructions on this. My lord. I sent a copy but have not received the instruction.
Mr. A. Samoa submits that he has not received any instructions from the respondent number 6. It also appears that the respondent number 1 to 5 have also not filed any affidavit. Taking into account the same, let the matter be listed again on 21st of June 2023. In the meantime, the respondents are directed to file their affidavits. An attempt shall be made to dispose of the petition on the next date.
Item 30.
Your lordship, the petitioner was working as an associate professor at Gargaon College, your lordship. And he is
Some time is
claiming-
required, lordship.
No affidavit filed?
No, lordship, some time.
What is this matter about?
Lordship.
What is your case?
Leave and catch.
Mr. Day, what is your case? You are challenging what?
Your lordship, she is asking for arrears of salary to the extent of 25% during the period, which was not paid to her during the period of her suspension. And also she has not been paid her leave encashment and GIS, group insurance.
Till now, you have not got.
No, Your Lord.
Lordship, sometime, Lordship.
Which department? Higher education.
Yes, Lordship.
Yes, higher education was better. What has happened now? Higher education never used to do such thing. They were higher. We have to put them in the same pedestal like elementary and secondary. Heard Mr. S.D. Learning Council appearing on behalf of the petitioner. Mr. D. Upamanu appears for the response number 1, 2, and 3. The case of the petitioner herein is that the petitioner, that the instant writ petition has been filed by the petitioner, claiming the area salary of 25%. How did this 25% happen? You got the 75.
No, Your Lordship. I've got 50% of the first 3 months under suspension. For the rest have not been paid.
Rest means?
For the rest of the period of suspension.
So isn't that 75%? Why are you asking 25%? I thought that suspension was done and then have you been exonerated?
The disciplinary proceedings were not initiated, Your Lord.
So under such circumstances, you are entitled to the full salary.
Reinstated, Lordship.
75% is the.
Understood. But if disciplinary proceedings, you have retired.
Yes, Your Lord.
So if the disciplinary proceedings have not been initiated, then under Rule 21, they can't initiate after without the orders of the governor. Isn't that the law? You have not seen.
I've just appeared for the first time today, Your Lord. I'm not very well versed with this case.
Oh, none appears for the petitioner on call.
Lordship, I am not very
No,
well.
no, first of all, why do you appear before this court without knowing head or tail about the matter? And are you not aware that Rule 21 categorically mandates that if a disciplinary proceedings is not initiated during the year, upon retirement, it has to be done only upon the orders of the governor. If not been done, then are you not entitled to the 75, the total salary for the period? Because there is no penalty. They can't reduce that amount. Isn't it?
I'm not aware of the law.
When can there be a pay cut? Tell me.
As a penalty, Your Lord.
Absolutely. Now, if there is no penalty, then there cannot be a pay cut. Now, therefore, when a person is suspended and thereupon he is reinstated and the departmental proceedings is dropped, then this period is always treated as a period on duty. And when he is treated as a period in duty, he gets back the entire salary. And therefore it arrears. Therefore I thought 25% because you must have gone, because initially 50%, then after 3 months, 75%.
Yes.
So that is why the 25% comes. That is why I was thinking.
That 50% has been paid, but the remaining 25 not paid.
Not 25, that this entire you see, after 3 months, you are entitled to 75%. But if there is no disciplinary proceedings, are you not entitled to that 25%?
That is what I'm paying for, Your Lord.
Understood. So that is why the 25% comes.
Lord.
But what about the remaining 50% out there for those 3 months?
That has been paid, Your Lord.
Not 50%. Wouldn't that be 100% then?
That has been paid.
That has been paid. The additional 50% was paid at the time of suspension, and 50% has, the remaining 50% has been paid, Your Lord.
So 100%.
So 100% for the first 3 months.
You got it.
Yes, Your Lord.
Now what about the other 75% you have got it?
Yes, Your Lord.
Till when did you retire?
On
Reinstated on 5/10/21 and then retired on 31/12/2021.
2021.
So this period reinstated, but there was no departmental proceedings here. So therefore you are entitled to that 25%.
Yes,
That is what I was asking you.
yes, yes.
And you are also entitled to leave encashment
And GIS.
Yes, sir.
and GIS. The case of the petitioner herein is that the petitioner is entitled to the arrears salary of 25% during the period of suspension after the initial period, 3 months of suspension, as well as also that the petitioner have not been paid the leave encashment and the group insurance scheme amount upon her retirement. It is relevant to take note of that the petitioner retired on
31/12/2021.
Huh?
31st of December 2021.
31st of December 2021. Further to that, it appears that being aggrieved, the instant writ petition was filed on 26th of August 2022. But till date, no affidavits have been filed by the Higher Education Department. Taking into account the above, list the matter again on 19th of June 2023. In the meantime, the respondent in the Higher Education Department are directed to obtain instructions as to why the petitioner have not been paid the remaining 25% of the arrears salary during the period of suspension after the initial payment of initial 3 months till reinstatement, as well as also why the petitioner have not been paid the leave encashment and amounts on receivable to the petitioner on account of group insurance scheme. No affidavit is required. You just get that instruction.
31.
Petitioner before Lordship Malot was an examinee in APSC examination in 2013 batch. That the batch against which the commission of inquiry was appointed by the government. And the commission of inquiry was appointed under the Commission of Inquiry Act 1952.
The one-man committee of the inquiry.
And the notification is at page 41.
Who are you?
I am one of the examinee in that examinations, Lord.
Yes.
And on my, I challenge that the results and all the procedure of examinations, that petition is pending. While that petition was pending, Lord, the government declared at page 41, declared an inquiry by a retired retired judge of this honorable court by appointing Honorable Justice B.K. Sharma. And his lordship has submitted the report on 2nd of April 2022. The Inquiry Commission of Inquiry Act Section 3 stipulates, my lord, if such an inquiry report is filed, then the government has to lay the said report before the House, means before the Assembly, State Assembly, within a period of 6 months. So my respectful prayer before this honorable court, a very innocuous prayer, the mandate of this act, to follow this mandate of the act and to lay down the report before the State Assembly. If I
you filed an RTI.
Pardon me, Lord.
Did you file an RTI for it? What are you asking for? Issued for making the report of the so-and-so regarding anomalies and a year to be made public by supplying a copy to the petitioner. Your prayer is not for laying it before the, that is not your prayer.
My lord, if lordship can...
I'm not going to see your prayer.
No, my lord, this is alternatively your lordship can mold the prayer.
Why should I mold the prayer? You have not asked for that.
No, my lord, I asked for a copy of the...
You have asked for the copy only.
we have submitted one RT application that was rejected.
No, the moment it is rejected, have you gone in appeal?
No, my lord, since it is not placed before the assembly, my lord, it is not a public document. Until and unless it is placed before the assembly, it is not a public document. So it
Can't private documents be taken?
No, if it since it is because the act mandates that it has to be placed before the house.
That is a different thing. That is not your case out here. That is not what you have asked for.
No, my lord, what my respectful submission is, I am prejudiced by non-submission of the.
How are you prejudiced?
Because I am the examining. My petition is pending. This particular report of the Honorable Commission.
If you are examining and your petition is pending, very well, then why you are not only asking for the report? You want the copy of this report? Very well. That's a different aspect of the matter. But why have you, what is that to do with you asking for placing it in the commission of inquiry?
No, my lord, the act mandates.
Understood. If the act mandates out there, fantastic. If the act is not doing it, isn't that the case out there? If the authorities, that is not your prayer.
No, my lord, my prayer will be.
And how does it have a connection with your writ petition?
No, I'm not saying that it has a connection. My respectful submission before Lordship. Otherwise, Lordship may put a question to me where is my locus?
No, that is why when you are asking something else, but your prayer is this, then this court gets disturbed on your locus.
My lord, I am explaining.
I had no problem with the giving. It looks very innocuous, but why you are asking something else which is not what is there?
There may be if Lordship allows me, my lord, or even my without amending my prayer, it's a writ jurisdiction. Lordship may hold the prayer.
No, there's a difference. There's a difference out there as to then we are to look into the Commission of Inquiry Act 1952 as to whether it is required mandatory or not. For that, you need specific pleadings for that. You want to do it, do it. There's no quarrel with that. But if you want to do it, then it has to be brought by way of a proper pleading, not by this manner. You are asking here, what is this? That so and so regarding anomalies and practices in the conducting the examination to be made public. That public is not required to be made public. Why should this court?
That is what.
But what are you asking? By supplying a copy to the petitioner. Very well. If you are restricting yourself with this, I will further go ahead. You restrict yourself to a copy of the petitioner, then I will further proceed. Otherwise, but if you are asking for the Commission of Inquiry, then there has to be requisite pleadings for that. You have to have the prayer for that.
Right. May I pray? When there is a law mandates something, and if it is flouted.
No. Then the question is your locus. Then your locus comes.
That is why
then otherwise go and file a PIL.
My lord, I'm explaining, my lord.
No, you file a PIL, not in a writ.
My lord, I'm explaining. If Lordship allows me.
I understand. If you ask this prayer is okay. I'm fine with this. But not as a prayer as regard the commission. If you want to do, you have to amend your petition or file a fresh petition to the effect I'll look into it. But not in this manner.
My lord, may I submit for an academic purpose?
No, there is no academic. We don't have the time for academic purpose. Academic, we go to colleges.
I deserve 1 minute time at least.
Fantastic. I'll give you more than that.
My respectful submission.
But Mr. Homo, you have to be honest enough out here to the effect that what is your prayer? Let us adjudicate on this aspect without the commission. If you want to do it, I'm going ahead. But if you want to bring the Commission of Inquiry, no problem. You bring it by amending this petition.
I understand, my lord.
But not on the basis that this court will mold the relief. Why should this court mold the relief in this matter? When your basic question is out here, because Mr. Samoa, your basic question out here is to that effect that I was an examinee of this examination. I have filed a writ petition or some proceedings are pending. And as such, I require a copy for that, for which I have filed. It is absolutely, this court is absolutely fine with that and will proceed with it. But if you are asking on the other hand, that I am an examinee, my prayer is only for a copy to me, but this court should further extend the prayer or the scope of the writ petition and then direct that this particular document be placed because it is the mandate of this. Why? Why should I do that?
Lordship is correct. Lordship is 200% correct from that perspective.
I don't need to be correct, but this is it. I have no problem. Once you ask that particular prayer, you have to include it. Because you can't put these people out there to a surprise to that effect. If they may have a opposition to that, this aspect of the matter, they may not say that this commission of inquiry, I have a right, and they have a right of filing reply to that effect. All these aspects will be. But you have to put that thing. I have no problem with that taking up. But only if you are limiting to this, or you amend it. Or file another writ petition.
Yes, my lord, so far as the question of amendment is concerned, that I need to take instruction from my client. And if
Because if you require instructions from your client for making an amendment, meaning thereby you don't have the instructions for that this play also should be argued.
No, my lord, I was praying for the alternative.
Mr. Samua, kindly don't extend beyond this. If you want this, okay, or file an amendment.
That is what, my lord, I need some time to.
Yes, please do. When do you want it? Or file a separate writ petition. Why are you amending?
2 weeks later, I'll.
Because if I'm telling you, if you amend it, the problem will be once you amend the petition, it will you have to first then you amend it,
petition.
and then thereafter again another
My
thing.
difficulty is this transport brief, my lord. It was under.
No, it's okay. You want some time for that, for including of this prayer.
My lord. That is why, my lord.
That
2
one.
weeks, my lord, will suffice.
Yeah. But what about the other you don't want? This prayer?
The prayer that we have made, my lord, that will remain, my lord. But we'll pray we'll pray before Lordship to add another prayer.
No? Or Mr. A. Samua, the learned counsel appearing on behalf of the petitioner. Mr. Who appears for the government?
Well, I am. For 1, 2, 3, 4.
Huh?
For 1, 2, 3, 4.
1, 2, 3, 4. And who appears for 5?
5 also.
5 also?
5.
Or 1, 2, 3, 4, and 5. Mr. D. Nat. Upon hearing the matter, the learned counsel appearing on behalf of the petitioner submitted that in terms with the Commission of Inquiry Act 1952, it is the mandate of the said law that an inquiry so made and the report be so submitted by the inquiry commission has to be laid before the state legislature within a period of 6 months. However, upon a perusal of the writ petition, there seems that neither there is any pleadings, nor there is also a relief sought for in that regard. The learned counsel for the petitioner submits that he would take instruction as to whether the petitioner would amend the writ petition or file a separate writ petition if so advised. Taking into account the same, let the matter be listed on
2 weeks later. Any date? 2 weeks later.
2 weeks. Today is 12. 31st?
Well.
On 31st of May.
God bless.
34.
If your lordship, this matter, with the respondents were supposed to file their affidavit first.
My lord, in this case, instruction is awaited. My lord, 3 weeks time may be granted to file affidavit.
What is this matter about?
Lordship, the petitioners are lordship, the retired employees of GMDA lordship. And the lordship, there was a initiation from the government as well as from the department and from the other DTT department also, where lordship, there is an initiation for providing pension to these employees who have joined in service prior to 2000.
Madam, you are appearing for?
GMDA, my.
And Mr. Gogoi?
For final.
And 4. The problem arises these matters now where only nothing is written. These matters come up after a long time and they don't file their affidavits.
First day lordship, the order
My lord,
was
today
short.
Huh?
First day order was short.
That is the problem. Huh? That is why it may take some time for writing that order, because once that order is then the authorities also know what is to be done. because he's just issuing orders to that effect. With due respect to my learned brother, nothing has been mentioned, so nobody did. It will just be rolling out there in the file. Nobody is bothered. But when you are making it specific in your order, then they will be, the authorities know what to do. Because there are also a lot of things, they have a lot of other works also. Administrative work only, not only to tender to all the court cases. So your case is what? That you are entitled to pension.
Lordship, there is an initiation, Lordship, and the initiation was not brought to the logical end, your Lordship. And there were minute, Lordship, there were recommendations from the clarification. From
Pension of each and everybody or one of the persons?
No, Lordship, all the petitioners are retired employees, Lordship.
Huh?
All the petitioners are retired employees.
So everybody has to pay court fee.
Lordship, I apologize, Lordship, if that is not done, your Lordship. I
Not
really
done.
apologize.
That is why nothing has
will do,
moved.
Lordship. That will do,
Don't pay the court fee. And I am telling you also, there is a move by the finance department now. Or the government is going to enhance the court fees. You may tell your friends that if it does so, it is going to be pretty high. Now we are paying only 50 rupees.
50 rupees.
If it goes up, like just for example, I'm just giving you in the Supreme Court, filing a writ petition is 2,500 per person. Court fee. Punjab and Haryana High Court is 1,250. Uttar Pradesh is 1,500. Writ appeal is 2,500. And our court fee is paid at 50 rupees. That too at the was done in 1972, which is almost, I think, 50 years, more than 50 years. So there will be an exponentially high rate now. Now, if you don't pay this, and these type of matters come up, and there is an increase to that effect, just see how much would be the burden.
I really apologize.
No, you need to do that, because you may tell your friends also, to those other matters, your colleagues, that all these things required to be done now. If you keep on paying with this, now it is just 50 rupees. Because that day I got a petition having total was 29,000 petitioners, one court fee. 50 rupees. I didn't notice that, but there was an application file there for the purpose of correction of certain names, because obviously when you put so many names, there is bound to have somebody's house has been, father's name has been wrongly mentioned, so they went. And the petition was this big. I said, what is this? My lord, we have to put first the name, and then again you have IAU have to file twice, the names. That has resulted in so big. And the petition was just 2 pages. Now, if it goes high now, Calcutta High Court is having 300. Punjab, as I said, Punjab, Telangana has 1,500. So this is going to go up. So once it goes up, then you have to pay as on that day.
No, Lord, I would have paid for 3 hours.
Eh?
It's overtime, Lord. I would have paid it today only.
No, not today. But this is going to happen. I just give it another 2-3 months. This is because the state government will notify that, because it's come under the court fees there. But this is going to happen. Because everywhere it has increased. It is only in Assam.
From some angle,
Huh?
it's necessary also from some angle.
Well, 50 years is too long a period. Huh? Yeah. Heard Mr.
DJ does.
DJ Das, the learned counsel for the petitioner. Miss Suti appears on behalf of the GMDA. Mr. B. Gogo appears on behalf of the Finance Department, as well as Mr. C.S. Hazarika appears on behalf of
Departmental Housing and Urban.
the respondent number 1. The case of the petitioner herein is petitioners herein is that the petitioner have not been paid, and the petitioner's entitlement pertains to the petitioner's entitlement for pension as well as pensionary benefits. It appears on record that on 25/11/2022, this court had issued notice, but none of the respondents have filed their affidavits. You have retired?
That's all right.
It further appears from the records that the petitioners have, all the petitioners have in the meantime retired. Taking into account the same, let this matter be again fixed on 23rd of June 2023. The respondents are directed to file their affidavits by 16th of June. Yes, you can file it. 16th of June 2023. The petitioner, if so advised, thereafter can file their reply by on or before the next date. It also appears on record that there are 8 petitioners. However, the court fee of only one petitioner has been paid. The learned counsel appearing on behalf of the petitioner submits that he would do the needful in that regard.
Much obliged.
I know 44 for order.
Yes.
Non-payment of arrears salary lordship. I will peruse the last court order
For the period from 3 months and which department? Secondary education
Secondary education, lordship.
and finance.
Finance.
Who is secondary?
Lordship.
Who is appearing for secondary?
Lordship, I am paying for.
Yes, what is your name? I've never seen you here in this court.
T. Thakuria, lordship.
P.
I am-
Thakuria. You're new into the secondary education department,
No, lordship, earlier.
but in some other courts.
Yes.
Because I only see Mr. P.N. Sharma, N.J. Khatun here.
Yes.
Anyways, why? They have not been paid the salary?
Yes.
Area salary for the period from 1/6/2019 to 28/2/2021.
Yes, lordship.
Why?
Lordship, till now we have not received any instruction, lordship. Finally, lordship, give me.
This order was passed on 36/2022.
Yes. 2 weeks time, lordship.
2023 matters of these area salaries are already disposed of.
Only 2 weeks time, lordship.
Heard, Mr. A.K. Das.
2 weeks time.
The learned counsel appearing on behalf of the petitioner, Mr. P.
T.
Thakuria,
Thakuria, lordship.
appears on behalf of the secondary education department, and Mr. B. Gogoi appears on behalf of the finance department. The claim made in the instant writ petition pertains to the area salary of the petitioner. For the period from 1/6/2019 to 28/2/2021. This court had issued notice on 36/2022. But till date, there is no instructions received as to why the secondary education department have not paid the area salary to the petitioner. Be that as it may, Mr. P. Thakuria, appearing on behalf of the secondary education department, seeks for an accommodation of 2 weeks to obtain the necessary instruction in that regard. Please the matter again on 14th of June 2023, on which date the learned the secondary education department shall apprise this court as regards the entitlement of the petitioner to the area salary from 1/6/2019 to 28/2/2021, and as to whether, and if so, when the said amount shall be paid. Liberty is given to the petitioner to mention the matter for upgrading.
46.
The area salary same.
Huh?
Same, lordship. Same. Order date, court order date 2/1/2020.
Matter pertains to non-payment of area salary to the petitioner for the period from so and so on the revision of year. He has been paid lesser salary. Heard Mr. A.K. Das, the learned counsel appearing on behalf of the petitioner. Mr. P. Thakuria appears for the secondary education department. Mr. B. Gogo appears for the finance department. This court had issued notice on 2/1/2023. However, the learned counsel appearing on behalf of the secondary education department submits that he has no instruction as regards the entitlement of the petitioner for the area salary of rupees 1,45,145 for the period from 1/4/2016 to 31/3/2022. The learned counsel for the secondary education department seeks an accommodation for 2 weeks in that regard. Lists the matter again on 26th of June 2023, on which date the learned counsel for the secondary education department shall apprise this court as regards as to whether the petitioner is entitled to the area salary. So today I was before time.
Yes.